Hello, everyone. I think we're getting close to, well, and I have 6:30 at this point. So I think what we'll do is we'll get started. I know we still have Mr. Hindle to join us, but in the meantime, bonne soirée à tous et bienvenue à cette audience en ligne du Comité de dérogation pour la Ville d'Ottawa. So welcome everyone to this online hearing of the City of Ottawa's Committee of Adjustment. My name is Anne Tremblay, and I will be chairing this hearing today. And with me today are my fellow panelists. We've got Ms. Kathleen Willis, Ms. Julia Markovich, Mr. Colin White, and Mr. Scott Hindle will be joining us shortly, I'm sure. From staff, we have, as always, a lot of support behind the scenes. So I'd also like to just note that both the coordinator, Cheryl Williams, is with us tonight. We also have Mandy Nguyen, who helps out, and Emily Manette from staff. So thank you so much, staff. We always appreciate your great support to us. So I'd like to just mention as we start out that the Committee of Adjustment is a quasi-judicial tribunal appointed by City Council to make certain decisions under applications of the Planning Act. And I think most notably people know that it's minor variances and consents, although there are others. And also just take note that this session is being video conferenced and live streamed on YouTube. The video will be archived along with the agenda on the city's website. So if you missed something, you can always go back and have a look. Just note the following information as well. While there's aspects, while there's a lot of things and aspects surrounding development within the city, there's a lot of things that the committee can't deal with. And I just want to present also Mr. Hindle, who has just joined us. So we have a full complement of committee members tonight. So just going back, so our mandate at the committee is actually quite narrow. We really can't consider any aspects to a proposal for which there isn't a variance requirement. So we really can only deal with the nature of the applications that are before us. We also can't really entertain complaints about noise or property maintenance or property values. While those are all very valid, this committee doesn't have any ability to affect those things, although we'll be happy to give you some guidance about how you might be able to do that. Also, we don't deal with prosecution for illegal construction. We will not entertain any personal comments about the neighbors or the applicants or the agents or anybody involved in these respectful proceedings. Also, we do not and cannot consider any additional variances to an application. So sometimes it happens that we realize that something might have been missed. And if it has been missed, we're not in a position to deal with the application if we have to add it. So in those cases, we have to, under the Planning Act, recirculate the application with that additional minor variance. And it could be even just as simple as greater relief required from the zoning bylaw. So as part of the statutory public notification requirements, each application is required to post a sign on the property and then to file a statutory declaration. And I believe that what we've been typically doing, and I will check as I go along, but I think for the most part, a sworn oath or a sworn oath or a solemn declaration is required if the paperwork on the declaration for the sign posting hasn't caught up with our staff. And I'm just taking a quick look, and it looks like we're going to be doing the oaths here tonight for all of the applications. So that said, with respect to quorum, so for technology connectivity issues, which have happened on occasion, if we lose quorum, and that's rare, especially if we've already got five members attending. But if we do lose quorum, we're going to try and let the technology resolve itself. Sometimes that happens. We'll pause. If we can't, for whatever reason, reestablish quorum tonight, then we will reserve the rest of the items to the very next meeting of the Committee of Adjustment. So in terms of the hearing process, we have an agenda. Those agenda items really just are listed on the basis of the order that they came in. The committee has a lot of discretion to decide whether or not we deal with some applications on a fast track or not. And in fact, especially with these online hearings, we found that to be particularly efficient. So we will be reordering the items and hearing them differently than what appears on the agenda. So when we essentially get to the item, we will call down or ask the agent to appear at that point. The committee may or may not ask for a presentation. If the committee does not ask for a presentation, then we'll simply ask questions for clarification about the application. From there, once the committee is satisfied that they understand and have all the evidence they need to continue, we will ask for the public hearing, the portion at that point in time. And anyone who has an interest in the application will have an opportunity to address the panel and to get some answers. That's what we're here for. If we don't, and I have very few, if anybody, on my speakers list for the night. So if you do want to speak, happy to hear from you, but we will need your full name. We may need you to spell your last name, and we will at all times need your municipal address within the city. So what the panel can do once the public portion has an opportunity to address the panel is also ask the speakers for clarification about their points. And we truly do want to understand the concerns that neighbors may have or stakeholders in the process may have with regards to an application. So once we've gone through that process, the committee will then be in a position to deliberate. And during the deliberations, we can make a decision. And the types of decisions, obviously, that we can make is to either grant the application or we can deny the application. We can also reserve the application. And what that typically means is that there's been a sufficient number of, or a sufficient amount of new evidence that's come forward that the committee wants to take a little more time to consider. And when that happens, we simply will hear all of the applications, we'll adjourn the overall hearing of the committee, and then we will re-meet. So what they do is they simply coordinate another meeting right after this one for the committee then to deliberate further on that particular or those particular applications and to make a decision. We can also, during the course of discussions at any time, decide that an adjournment on the application might be, in fact, more appropriate. And so that's essentially rounds out the range of things that the committee can do on this. And of course, once the committee makes a decision, that decision will be essentially issued within 10 days of the hearing, and that it will describe the reasons for the decision by the committee. And also just like to note that those decisions are subject to a 20-day appeal period, during which time a decision can be appealed to the local planning appeal tribunal for a fee. So with that, we've got a few items of business before we get into the applications. Any declarations of conflict of interest either on an item that's appearing before us tonight or that has appeared before either panel 1 or panel 2 earlier today? So yes, Ms. Markovich, please.
Yes, Madam Chair, I need to declare on application 1415 33 Landry Street. And the reason is, do you need the rationale now or?
Oh, no, sure. Yes, for the record.
Okay. It's just simply geographical proximity. I live within a few blocks of the subject property.
All right. Thank you, Ms. Markovich. Mr. White.
Yes. I must declare interest on a couple of items on our panel 3 agenda today. Item number 1 and 2 and item number 10 at 1 and 2 are 43 Norway Spruce, I think is the name of the street. And then the other 10 Ashton Station Road. Declare interest because I periodically do sub consulting work for the agent on those particular applications.
All right, thank you, Mr. White. Anyone else? All right, okay, in that case, we'll move on to the next, which is the adoption of the minutes. We have quite a number of of minutes to adopt this evening. So starting with August 5th, do I have a motion to adopt? Yes, Ms. Markovich, and seconded by Mr. White. On the August 19th minutes, do I have a motion to adopt? Ms. Willis, seconded by Mr. White. On the September 2nd minutes, do I have a motion to adopt? Ms. Markovich, seconded by Mr. Hindle. On the September 16th minutes, motion to adopt, Ms. Willis, thank you, seconded by Mr. Hindle. Thank you so much. I think that rounds out essentially all of the items that we had, all of the minutes that we had to approve at this point. Okay, so now we have a number of adjournment requests, and we have, in fact, 4, and there's probably one that we want to call down. So based on that, I'd like to start with application number, well, item number 7, which is for 762 Quinn Road. So that is, and who do I have here to speak to that? I'm looking at Mr. Wright. Mr. Wright, are you available? Sorry, I'm going to need to there's a little activity going on in my house, so hang on. Sorry, I'm looking for Mr. Still looking for Mr. Sorry, Mr. Wright? Is Mr. Wright available?
We don't see him on the attendees list, Madam Chair.
No. Okay. All right. Let's step it down. We'll come back to that one. Did Mr. Wright mention, Ms. Williams, whether or not he was going to be appearing as a result of the adjournment or to speak to the adjournment at all?
He didn't mention either way.
Okay. All right. In which case, we're going to go to the next one, which is items 14 and 15. Which is for 33 Laundry Street. And I'm looking for, let's see, who am I looking for here? All right,
Chair,
Mr. Straka.
sorry to
Yes.
interrupt. I believe Member Markovich has to.
Yes, I think I need to depart for while you have this conversation.
All right, yes, of course. All right, so I'm looking for Mr. Straka. Come on forward. Oh, there you are. Great. Okay, so Mr. Straka, you're aware that there's a request for adjournment on your 2 applications?
Yes, I am.
Okay. Any concerns with the adjournment request?
No, I've read and discussed the comments provided by staff, understand why the adjournment is being recommended, and we do agree to pursue the phase 1 and 2 ESA along with an RSC before coming before you again.
All right. Okay. So we are adjourning sine die and not to a date moving forward. All right. So any questions on that by the committee before I request comments on it? Mr. White.
Thank you, Madam Chair. I just have a question because this sort of has some relationship to a subsequent item on the agenda that we're going to be dealing with respect to a similar issue. I notice in the report that planning staff prepared that they refer to concerns with respect to the lack of the ESA having been done. They also indicate that further to the official plan, section 4.8.4, contaminated sites, and the statement is that ESA should support applications at the time that the applications are reviewed. I think that's the basis on which we're deferring this application. I believe in a subsequent application, I think we may want to have some discussion with respect to that as well, at that policy and its application to that subsequent application.
All right. So we should have that discussion likely now. So we've got Ms. Ramirez on the Landry Street, and I believe looking at Buttonfield.
That's the other application.
Mr. Hodgins. So So Ms. Ramirez and Mr. Hodgins, what we sort of noted is that there's very similar items or concerns or issues with regards to both applications, but not necessarily a consistent approach to dealing with them. So I guess I starting with you then, Ms. Ramirez, because we're dealing with the laundry, could you please explain to us what you see as being the basis for, like, so we know we need an ESA in phase 1, we may need an ESA phase 2, and then from there. So can you just, from your perspective, tell us, what it is that you would expect from those products as part of your review of the application, so that we can understand how to deal with both these applications.
Right. So the phase 1 ESA will go into the history of the lot and will provide documentation and assess whether or not there is potential contamination. The phase 2 ESA will do some sampling and investigate if there is that contamination. And then both of those are required for the submission for the record of site condition, or it's anticipated that both of them are required. And so staff would be in a better position to make comment on the severance once we have staff has reviewed the phase 1 and the phase 2 environmental site assessment.
Through you, Madam Chair, if you don't mind, I might jump in and provide some clarity to this. So you are correct. On the Buttonfield application, we previously requested an adjournment requesting a phase 1 ESA and a phase 2 if required. As you know, we were provided phase 1 ESA yesterday afternoon, and we had reviewed it. Our decision to remove our request for adjournment for that item kind of stems from the results of the ESA, and that there's been prior soil testing done on the site. So in the case of Buttonfield Place, we're comfortable enough proceeding with the application, recognizing that the phase 2 ESA will need to be provided as a condition of approval, and that the record of site condition will be a condition of approval as well. Again, in that case, there were some mitigating factors, such as the results in identifying potential contaminating activities that happened on the site. It's contained to a specific area, as well as there's some soil testing done before. So I think that's likely why you're seeing a discrepancy at this point. Our original request for Buttonfield for phase 1 and 2 ESA was at a time when we didn't know fully what was going on the property. And we didn't want to relinquish the right to want to review it at phase 2 ESA. I think there is possibilities or sites where staff would have wanted to see the phase 2 ESA while making a decision on the application and providing our comments. But in the case of Buttonfield Place, staff are comfortable enough proceeding. We do note, however, that the official plan section Mr. White referenced does talk about having it as part of the application. So we do recognize that, and we're going to bring that to your attention for the Buttonfield application. I hope that kind of explains the differences in approach between the two.
Well, thank you for that, Mr. Hodgins, and that's actually very much the focus of what the issue is for us. So if the policies are truly saying that for development feasibility purposes, we really should be looking at the results of a phase 1 and phase 2 before we make a development decision, then I think where we are at this point is that we would like to essentially consider maybe an adjournment of both until those documents are in hand, and that staff can include that as part of their comments back to the committee. So that's kind of where I think where Mr. White was, not to put words in your mouth, Mr. White, but I think that's sort of the direction we're trying to head in here.
Yeah, Madam Chair, I wonder if we could discuss the Buttonville application separately from this one, get into some more discussion on that once we've dealt with this application. Would that be in order?
Yeah, and I think the reason why we're dealing with both of them is because we're trying to be consistent in our approach. And if the policies essentially say that having both the ESAs, phase 1 and phase 2 in hand is in fact, not a requirement, but prudent in the terms of making planning decisions, then we might want to make that call now. That's all I'm suggesting.
Yeah, I'm wondering, I think I'd kind of like to hear from the applicant or the applicant's agent on the Buttonville one before
Buttonfield one as well. Okay, I mean, fair enough, fair enough. I guess we were just trying to get some clarity here in terms of how this all relates. And I guess, you know, so Mr. Hodgins, I guess from my perspective, the fact that an ESA phase 1 has been done for Buttonville and actually has suggested that there's something there and a phase 2 is required, then it already tells us that there may be some underlying, you know, some additional issues that need to be dealt with as part of development. So anyway, all this to say, we're going to go back to Landry then. And I think at this point, committee, we're proposing an adjournment sine die until those two reports are done, correct? All right. So just let me go out to the public. Is there anyone in the audience that's listening in and has an interest in this application that would like to speak on the proposal for adjournment, sine die? Okay, I'm not seeing any hands go up. So on that then, committee, we're adjourning, sine die. All those in favor? All right, so it's unanimous. We are adjourning your application, Mr. Straka. Thank you so much for appearing with us, and we will see you in the future, I'm sure.
Thank you.
All right, thanks so much. Okay, that brings us to, and I'm going to propose we actually deal with the Buttonfield one at this point, which is application item number 17, and it's 6078 Buttonfield. And I believe we had, who's our agent? Mr. Bekesh, Buttonfield. Mr. Bekesh, I see you're here. Just need you to appear.
Hi there.
Hi there. So you're aware that staff had originally been proposing an adjournment to this application, and now there seems to be some varying circumstances that suggest that we should be waiting, or not, that we can hear the application and condition it to a phase 2 coming forward. Can you explain to us, you know, how you feel you can in fact demonstrate development feasibility going forward? So what kind of circumstances do you think we should take into consideration if we were to condition this instead of adjourning?
So at the present moment, before I even purchased the property, we did conduct a soil sample test in 3 different locations of the property, going down 6 feet into the ground. We obtained those samples. The samples came back negative, trace amounts for any contaminants within that lot. We've gone through the phase, ESA phase 1, and the report that was presented to the City of Ottawa yesterday afternoon indicated for 2 circumstances. The first circumstance is basically the property was expropriated back between 2002 2005 for the widening of Innes Road. There was an old bungalow built in the 1970s on the lot. One of the reasons why they're saying that phase 2 is required is because at that point, the engineer is unable to determine whether there was an above or underground storage tank for heating oil. However, when the property was expropriated, that portion that the house sat on was expropriated by the city. The city demolished the house and backfilled whatever property the city currently owns where that house laid. So from that aspect, looking at it, that land is pretty much owned by the city and was addressed by the city in 2005, 2006 when the property was demolished. The other concern that's triggering it is that there was a small engine repair. It was an illegal business that was operating on the property for a number of years. It's a small engine repair shop dealing with snowblowers and lawnmowers. From my perspective and the soil sampling test that we've done, and the results came back, it was a very small operation. The amount of contaminant that they were dealing with potentially wouldn't have an effect on the property so much so as a full industrial automotive shop or a car repair garage along the lines.
Okay, any questions for Mr. Bakash about that history? The panel? I have a couple of questions because I'm looking at the condition that gets at the phase 2, and I know, Mr. Hodgins, that you had suggested that if we were to hear the application, that we would modify the condition to obviously recognize that the phase 1 ESA has been done. But I guess my question to you is, and we're always cognizant about trying to clear conditions so that if we're considering a severance, for example, that can in fact happen because you can clear the conditions within the statutory timeframes of 1 year. So if phase 2 comes back and identifies a number of remediation works, is it the intent of your conditions simply to get at the report that says that a lot of particulars, that here's the list of things that need to happen in order to remediate the site, that's the condition that needs to be cleared? Or is there an expectation that there's an actual remediation of the site? So I'm just trying to figure out where that part comes in.
Through you, Madam Chair, the remediation would be required prior to issuing the record of site condition. So remediation would have to occur if required prior to clearing that condition, as the second part of it requires the record of site condition.
Okay, and I guess I'm just mindful now back to the timeframes for clearing conditions. Is that realistic?
Through you, Madam Chair, staff discussed internally yesterday and today, and it may be possible, but we would likely defer to the applicant on that to discuss if they've discussed it with their engineer and to see if they can meet that within the 1 year time frame. That would be really the only concern from the city's perspective if it could be met. But again, we're making this recommendation, or we're comfortable proceeding without an adjournment based on what was done as part of the phase 1. So in terms of that, we'd likely defer to the applicant for timing.
I see Mr. Bakash has his hand up, so please,
Yes.
go ahead.
I'd like to comment on that. And I'm concerned that potentially if the conditions go through at this point and the severance is approved with the condition of meeting these expectations, and I lapse in the time frame, 1 year time frame, that I could potentially be subject to reapplying for a full severance, again, incurring additional cost. And I do have some concerns with meeting those expectations. Is it discussing it with the engineer? He does not see or think that the lot is contaminated. However, again, you cannot be sure once we start digging and finding anything. But again, we're confident that the soil is clean, but I'm just unsure whether we can make that time frame. And that's my concern with meeting that 1 year expectation and being in the position to have to reapply for an approval again.
Mr. Bakash, I think what I'm hearing is, in fact, that maybe an adjournment to, we don't have to do it sine die. We could actually adjourn it to, maybe 2 months' time, something like that, to give you some time to actually get more comfort with regards to that. Because I think that the 12-month timeframe is rather tight, to be honest with you, especially given the conditions that we're in right now. And if you want to spare yourself that expense, then an adjournment is a very viable way to do that.
I think under the circumstances, I'm a little bit more comfortable with that. Maybe instead of a 2 month, I'm not sure what your policies and procedures are for adjournments. Is 2 months enough? I would like a little bit longer if possible, but again, that is up to you and what you feel is necessary for adjournments. So
I can answer that. So the issue is due public process. So I think the most we tend to push things out in terms of adjournments at the very most is like a 3-month window. Anything beyond that, typically we would like a recirculation just so that so anyone who is affected by the application gets that again. And in this case for Buttonfield, Ms. Ms. Brennan, could you please tell us what that recirculation fee would be? Certainly a lot less than a reapplication fee, but how much is the recirculation fee? If we were to say, we're going to sine die and in this case, know that it's going to come back, or what would that recirculation fee be?
Madam Chair, I'm just checking our fee schedule. There's no variances involved in this, so we would be looking at an application fee. And if staff has the fee schedule up, I believe it's $689, something to that effect. $662. Sorry, Madam Chair, $662.
All right, so that being the case, that's probably a better dollar value for you to deal with. If you'd like to buy that, because now if you do the adjournment sine die, then you have a lot more time to breathe and to get the work done that you need to get done. If you think you can do it within 3 months, I'm willing, and I'm not alone here, I'm looking for input from the rest of the committee. If you think you can get it done within 3 months, I'm okay with going to another date, and then you would not need to have the recirculation fee, but I'm looking for comments from the members. In support of 3 months?
I'd be supportive of whatever the applicant thinks is realistic. I think ultimately sine die is probably the safest bet, but I am concerned we already have adjourned once, that the further out we go, the more we people in the neighborhood may forget about this application.
Good point. It's not the first adjournment, so that's a very good point, Mr. Hindle. Mr. White?
Oh, Madam Chair, I'm just wondering if there's, if there's anything stopping us from adjourning the matter a second time following the applicant's investigation of what the expectations are for the timing of this of the ESA work. Is there anything obstructing us? I don't think there's anything obstructing us from granting a further deferral for a couple.
No, I don't think so. No, it's at our discretion. It really is. As long as there's not an abusive process, Mr. White, I think that's all we're really concerned about. So, so Mr. Bikesh, back to you then. Would 3 months be sufficient, do you think?
I think so, yes. I think
Perfect.
3 months it would allow me enough time. I do have one question or comment to the board, and I'm not sure if the board is aware that there was a previous application that was filed for this particular property by the previous owner, which was reviewed and approved by this particular panel within the last 18 months and granted a severance without an ESA or ESA phase 1 or ESA phase 2. And I'm a little troubled and concerned, which I'm currently addressing the issue with the city of Ottawa, but I'm really concerned of the circumstances surrounding both applications, why one application was not, one application was actually approved by this panel, and the second application within 18 months is facing such a challenging hurdle. The only difference between the two applications is one, the previous applicant was severing for 2 lots. I am requesting to sever in 3 lots. The previous applicant was a Caucasian Francophone, and I am a person of color. And I'm very troubled by the hurdles that I've had to face with this.
Mr. Bikesh, I cannot speak to that, but I would be interested in knowing why the severance, so why did the severance not occur then if it had been approved? Can you tell us what the circumstances were around that?
I believe that the original, the previous owner had lapsed in time for meeting the conditions of the lot. And she just ran out of time, and I ended up purchasing it from her.
So, Mr. Bikesh, I can tell you I've been on the committee for a long time.
Sorry, I'm unable to hear you.
I said I've been on the committee for a long time, and I can tell you that this wouldn't be the first time where a committee had approved something. For whatever reason, there's been either a change in circumstance, and so I don't know in this case. I don't profess to know what the background is, but it's happened before. I wouldn't tell, like, in my mind, I don't think it has anything to do with some of the concerns that you have. I think it's not that, but in any event, we do have a policy in the official plan that still speaks to that. So one way or the other, the policy, it does need to be respected. Maybe it got missed. I'm not sure. And so we would just like to be mindful of that. Mr. White, you have something you'd like to add?
Yes, Madam Chair, I'm assuming that on the previous application, I don't have recollection of it, but I'm assuming on the previous application, the issues were not identified and presented to us. And obviously, if they weren't, we're not in a position to apply conditions that are not forthcoming from staff recommendations. So I'm assuming that's the situation, but I don't think it was this committee that would have made the decision differently than what we had been faced with as far as the recommendations from staff.
Try to be consistent. We do try to be consistent with our decisions. So that's it. Okay, so if we, so Mr. Bickett, back to the timelines for the adjournment. You're good with 3 months.
I am.
I think the committee is willing to support you. So Ms. Branning, what date would that bring us to?
Madam Chair, the 2 hearings in April are Wednesday, April 7th and April 21st.
Let's go with April 21st. That gets us a little bit further into the spring and allows for whatever work might be done. We know a lot of stuff is stalled right now with regards to trying to get some work down, especially based on the announcements that we heard today. So on that basis, let's go with that. Now, before the decision final, I do need to ask if there's anyone in the audience who would like to speak either for or against this request for adjournment. All right, seeing none, I think, Mr. Burkett, you've heard from the committee. We'll see you back in April. And
Thank you
hopefully
so much
you'll have your work done and you'll have the results, and hopefully everything will be in order and we can proceed with your application.
Excellent. Thank you so much to all of you for your time. Have a good night.
Great. Thanks so much. Have a nice evening.
You too.
Okay, so have we seen Mr. Wright? Has Mr. Wright come back by any chance? No, I am not. I guess I'm not seeing that.
He does not appear to be in the attendees list.
All right. Well, we'll step him down again and we'll see whether or not maybe he's just delayed from something. Okay, so the next one that I have for adjournment is item number 16, and it's for 799 Melfa Street. And I believe for that one, who have I got as an agent? I'm looking for Mr. Poulton.
Good evening. My name is Ryan Poulton. I'm a planner at Novatech, and I'm acting as agent on behalf of the owners for this property.
All right. Good evening, Mr. Poulton. You're aware that there's been a request for adjournment on this application?
I'm aware of an initial staff report that was sent last week asking for an adjournment. My understanding is a second staff report was sent yesterday to the Committee of Adjustment withdrawing that request.
Okay, so the committee has had a chance to look at the application and to, I believe there was actually an email or a letter that came in from the homeowner who is actually encroaching on the property. Is that correct?
Yes, to the north at 789 Melfa Crescent.
All right, Mr. Poulton, can you tell me why a lot line adjustment hadn't been considered to deal with that encroachment before we deal with severance to the subject property?
Can I speak to that, please?
Yes, Mr. Chan, you can.
Thank
As long
you.
as I get an answer from somebody, that'd be great.
So there were discussions with our client about a lot line adjustment. The actual ultimate solution that both our client and the neighbor to the north agree to is that over time, the encroachment will be removed. It's not like it's a permanent structure or a building that warrants a lot line adjustment. It's simply an interlock driveway and a carport, which is really just a canvas cover on a bunch of 2x4s. So there's no permanent structure encroaching. So it didn't warrant a lot addition application, and neither party wanted to go down that road.
Questions for Mr. Chow from the committee? Or Mr. Bolton?
Yeah.
Yes, Mr. Handel.
So I'm curious then at that point, are you intending to go forward with a kind of a more official encroachment agreement, or is this just an understanding kind of between parties at this stage?
There's no intention to go forward with anything formal. The expectation is that someday the property to the north will redevelop, and it will have to fully conform to the zoning bylaw when it does. In the meantime, as I say, both parties were prepared to continue to live with this existing situation, and it may be of interest to the members of this panel of the Committee of Adjustment, but we had the exact same circumstance in front of panel 1 this afternoon. Only the difference there was it actually is a building that's encroaching on our client's property, and the owner of the building that encroached had no interest in a lot addition application. We actually started there, but he wasn't interested, so we withdrew that application. And the committee, panel 1, approved the severances this afternoon with that encroachment in place, and it's a far more permanent encroachment than what we're talking about this evening.
All right, thank you, Mr. Chown, for the history of panel 1. As you know, we deal with the applications on a case-by-case basis, and so although that information is good to have, it by no means precedence for this panel, as you know, to adhere to. So
I raise it for your information so you're aware of what your colleagues have done. And in terms of the application that's before you this evening, whether there's an encroachment or not doesn't affect the severance application that's before you. The severance application before you is not creating that encroachment. It's simply an existing condition.
So, Mr. Hodgins, I do have a question for you then. Under the bylaw, so what we've had described to us by Mr. Chown is 2x4s and a canvas top carport. I haven't seen it. We, of course, are being discouraged to do any kind of site visit, so we really don't have a chance to know what this is. But I guess I need your opinion as to whether or not, under the bylaw, what Mr. Chown has described is a structure.
Through you, Madam Chair, I believe I would agree with Mr. Chown in the fact that it is a carport and some driveway that encroaches on neighboring property. I would believe that a carport would be considered a structure under the zoning bylaw. So the answer to your question would be yes, would be my interpretation.
Mr. Chown, is that carport being used actively now to actually park a vehicle? Oh, sorry, you're on mute. Mr. Chown, you're on mute.
Sorry, I put it on mute because I know there's often feedback. We do have a photograph of that property in our presentation package, which we could share with the committee. But the answer to your question is, I believe that yes, it is being used to park.
All right. Okay, so committee, I guess we need to chat a little bit about this. Ms. Willis, go ahead.
Just a question for Mr. Chown. So is your client intending, I guess I don't really need to know that. I'm just curious as to what will happen if the lot changes hands. Presumably it's going to be sold either with a house on it or as a vacant lot. What happens in terms of timing of development if construction is to start on that lot and this encroachment is impeding that construction?
Well, it barely encroaches on this lot, and it's a very substantial lot. The purchaser of the vacant lot that's being proposed this evening will have lots of room to build a fully conforming single-family home on that property without ever running into a conflict with that encroachment.
And I'm assuming then that any information would be divulged. It's obvious on the survey plan that there is an encroachment, so they'd be going in with their eyes open.
Absolutely.
Thank you.
All right, thoughts from anyone else on the panel? All right, I'm just going to make one more comment, and I'd like some feedback from the panel members on this too before we decide what to do exactly. I guess at the end of the day, when you create a lot, in my mind, creating a lot with clean title is sort of an important element for us to consider. So if that being the case, at least from my perspective, and again, I'm looking for some feedback because what I don't want is for us to go down the road only to find that there's more of us that sort of maybe are leaning this way. But if in fact we see that that this would not be creating clean title, and either an agreement or something should be in place in order to protect any future prospective purchaser of the property, then either we wait for that to catch up, we adjourn and wait for that to catch up, or we deal with the application knowing that the approval would result in exactly what Ms. Willis has just described. I'd just like some thoughts from others on this before we move on.
Madam Chair?
Yes, Mr. White.
I'm just wondering if there is, it's a very unusual situation, if there is something that we might be able to impose in terms of a condition that will have the effect of putting on notice any purchaser of that parcel that's affected by the encroachment, putting them on notice better than simply having it on a plan of survey that may not necessarily be looked at by prospective purchasers. I'm not sure how to do this, but I'm thinking of some kind of condition in a decision that would flag that problem for any subsequent purchaser of that parcel.
I think that would be pretty novel. I'll be honest, I haven't seen that. I'm not saying it's not doable, but I have not seen that. We would have to get a lot of guidance in terms of the wording for something like that.
Well, I'm thinking it might be something similar to a noise exposure clause, something like that, but simply referring to this encroachment issue.
So let's think through this. So if we did that, then we would require a development agreement as part of that condition in order to have the leverage to get the notice actually. So there has to be some sort of requirement to do it in order to get it on title. And then that would be what would be cleared, right? So you'd get the development agreement, and then you would get the notice on title of words that we would say something like of satisfaction to our legal services, that would be, because we don't have the wording with the noise, as you know, we already have the wording. So we would be able to add it to the condition directly. So we'd have to sort of think about how we're going to do that.
I think Mr. Chow might have some ideas here.
Yeah, I see that. I see his hand is up.
I've learned my lesson, Madam Chair. I'll try not to interrupt like I have on other evenings. I think we might be able to do something like what Mr. White is suggesting. We're going to be asking the committee when we finally, assuming we get to the item, we're going to be asking the committee to impose a condition requiring a warning, exactly what Mr. White is talking about, a warning clause with respect to aircraft noise, rather than making our client do a noise study. And if the committee was agreeable to a condition with a warning clause for with respect to aircraft noise, then we could roll into that something with respect to acknowledgement of the existence of the encroachment.
All right. Okay. So I think we're still at the question of adjournment, but I guess what I'm, Ms. Brenning, did you have something you wanted to add?
Yes, Madam Chair. I just wanted to add that since this would be between two parties, I'm not sure if the city would even, we would have to get some input from our legal department, whether the city would even entertain a condition of that nature, considering it's between two private property owners. Just put out that.
I don't think that's what Mr. White was suggesting. Mr. White was just simply suggesting notice on title to the purchaser of the vacant lot to make sure they're aware of the encroachment. And I'd remind the committee that staff have changed their position. Their request for the adjournment didn't have anything to do with the encroachment. Their request for
Oh,
the
I know.
adjournment.
We kind of raised that one ourselves. It's true.
Okay,
Just-
thank you.
So that's part of, I guess, it's part of our rights and our privileges, I guess, as members of the committee to do that. Mr. White and then Ms. Willis. Actually, let's go to Ms. Willis. We'll come back to you, Mr. White.
I don't have an issue with putting a warning clause on title if the applicant is agreeing to it, recognizing as well that the encroachment may be long gone before title is changed, so it may not, the problem could go away. But I also am quite prepared myself to deal with this tonight with or without that warning clause, because we're not, as Mr. Chown pointed out, we're not making a situation any worse. That problem exists today. If that property was to be sold in its entirety, the same encroachment exists. I'm very much a proponent of buyer beware. It would show up on any survey plan. So I don't see it as an issue. If it becomes a problem with putting something on title, I'm prepared to deal with the application tonight.
All right. Thank you very much, Mr. White.
Madam Chair, I've heard from Mr. Chown that they would be prepared to accept some kind of warning clause incorporated in the agreement that's required with respect to the noise. On that basis, I'd be willing to consider the application and not require an adjournment.
All right, thank you. The other two members, Mr. Hindle, Ms. Markovich, any concerns with moving forward?
No, I tend to agree with Willis and her thoughts that really we're not making this situation any worse, at least today.
Yeah, I would support that as well. It seems like we've been able to arrive at a way to go forward today and hear it.
Great. Okay, good. So then on number 16, we are going to hear this application, and I'm going to put it in the presentation pile. So we'll hear from you a little bit later. It's going to be a long night, gentlemen. So it might be a little while before we get back to you. So, but we will. All right. So with that, we have, let's see, there's one application for which there was no request for adjournment, but the committee is perhaps interested in a discussion about this. And I see that the agent on file is Mr. Segreto. It's for item number 10, 2899 Innes Road. So Mr. Segreto, are you there? Can you come forward, please?
Yeah, hi, good evening.
Good evening, Mr. Segreto. So we've, the committee's had a chance to look at the permission that's being requested with regards to this. And we see that, just clarify for us or confirm for us. So the intent here is to demolish the existing building and to the house, the existing house, and to replace it completely with a new house that would be of a larger footprint, but but a more modern house on that lot. Is that correct?
That's correct. I have the owner here with me this evening, but the whole idea is that the house, basically the house is dilapidated and it hasn't been lived in for about 5 to 7 years. I'm not sure. The owner can talk on that, but you're right.
I just want to know. Okay, and
Yes.
and the footprint of the house is going to be larger than the existing.
Not really. Very slightly larger, maybe a foot or two bigger.
Not the foot.
But it is larger. All right. So you know that can be an important point. Okay. So I'd like to speak with Ms. Ramirez. Can we have Ms. Ramirez come forward?
Yeah.
Please?
No, wait. The planner.
So Ms. Ramirez, we've looked at this, and I'll be honest with you. You've got a lot of planners on your panel, right? With experience. That's maybe dated experience in some cases. I'm not going to make a comment about the quality of that experience, but I think so I guess we're trying to figure out whether there's been sort of a change in the interpretation going forward in terms of where the direction the city wants to go in with these properties that have legal non-conforming rights. And I'll just let me give you a little bit more background. So what we're kind of thinking here is, it had always been sort of the committee's experience in dealing with these kinds of applications that when there is a demolition and there is a replacement of the structure, that it would then have to be in the direction of the underlying zoning, which in this case, as you know, is commercial. So I guess we'd like your thoughts on that, because to be honest, we were kind of thinking it would be nice to perhaps get more of a legal position on this than what we have. And the reason being because, as you know, it can run the other way. So if the intent is that the city is saying that, no, we're willing to entertain legal non-conforming uses that are demolished and replaced with the same, it's fine if you're going residential to resident, staying residential in a commercial zone, but it's a different story if you're a commercial zone or commercial use in a residential zone and you're doing the same thing. Now, so we're just a little bit worried about the underlying principles here. So can you give us sort of what the departmental position on this is today? Is it a change in position? Is it? Go ahead.
Yep. We're going to.
For you, Madam Chair, the owner would be able to rebuild the existing, the dwelling. I understand that the owner would be able to rebuild the existing dwelling within the footprint. And the reason that the permission application has come forward is because they're looking to expand outside of the footprint with the rear yard setback as well as the height. My understanding is that the commercial zone was related to the proximity to the road, which is collector. And it was, I understand that zoning was put in place prior to the bypass, Blackburn Hamlet bypass being constructed. I would be happy to seek an adjournment to get legal to weigh in on it more, if that would give some comfort to the committee.
Okay, the only reason why we raised it is because we are aware that if we're going to begin to apply this as a principle in making decisions with regards to permissions on legal non-conforming uses, that becomes a principle that is portable to all kinds of different situations and not just one where it's residential. So our thoughts from the committee on this again. So are you comfortable proceeding? Would you prefer to have more of a legal background on this one before we proceed with it? Mr. Hindle.
Yeah, I would tend to prefer to get a little bit more confirmation from legal just on the interpretation of this section of the Act. Because ultimately, I think my gut is that if it burned down, you could rebuild, no problem. But other than that, it tends to more be a renovation that's permitted and not necessarily a wholesale rebuild. So I would appreciate, I think, a little bit of just confirmation of that from legal as to how this section should be interpreted. And I think I generally agree with the direction of the outcome that's proposed here, but there's just some weird technicalities with the Act and how this section works that I'd want some comfort with.
All right, thank you. Anyone else? Mr. White.
Madam Chair, I agree with Mr. Hindle's take on this. I think the Planning Act gives us the flexibility, but the circumstances here are a little bit beyond the scope of or outside the scope of the actual wording of the Act. So I'd be inclined to say that we should maybe get some clarification from legal, and I think we could get that fairly quickly before the next meeting.
I agree. I think it is possible to get that clarification. So, Ms. Ramirez, and I just want confirmation from you. Then you'd be able to get for us maybe more of that background, more of that comfort in terms of the Planning Act requirements. And I think in some way, I guess I would ask that you get legal to also signal to us sort of the circumstances where, in fact, a rezoning might be appropriate rather than using the permission route. So there must be a line in the sand somewhere that at which point, you're really looking at a rezoning of a property. And I'd kind of like to know where that line in the sand is as well. including the interpretation. So, all right, Mr. White.
Madam Chair, yeah, I'd like to also get some clarification as to if we're predisposed to approving the application, what sort of bylaw setback requirements, et cetera, that we should be looking at in terms of the new development, because obviously this is not in conformity with the existing zoning. So, what's reasonable as far as development standards and performance requirements?
I think that's an excellent point. So, Mr. Segreto, I guess you've been listening in on our exchanges here. The next meeting of the committee is February 3rd. Can I get confirmation from Ms. Brenning on that? Or, yep.
Yes, Madam Chair. Yep, it's February 3rd or 17th.
All right. Well, I think February 3rd is 3 weeks away. I think that gives us plenty of time. So, Mr. Segreto, would you be willing to? You're on mute, Mr. Segreto, so I can't hear you.
Nope, I don't have an issue with that. That's fine. We can meet in 3 weeks from now.
All right. Okay, that sounds good. Okay, so before we actually make a decision, is there anyone in the audience that has an interest in this application that would like to speak to the request for adjournment or the proposal for adjournment to February 3rd? Okay, I'm not seeing that, not seeing anybody raise their hands. So with that, then committee all in favor of an adjournment of this item to February 3rd, we're unanimous for the record. Okay, so Mr. Segreto, we'll see you back at that time, and we look forward to getting. We love legal to provide us with some clarifications on some of these things. So we look forward to getting that. It'll be helpful to us for sure. Okay, thanks so much. I don't know if you have any other applications, Mr. Segreto, but we'll see you. Yes, go ahead.
One more. I have one more.
Oh, you do have one more. Okay, good. All right, so we'll see you a little bit later.
Yep.
Thanks so much. And I think that takes us to the end of our adjournments, other than, of course, if Mr. White, or not Mr. White, sorry, Mr. Wright has come forward. All right, so committee, what would you like to do? If Mr. Wright, and it doesn't, I mean, we could step it down till the very end of the meeting, and if we haven't heard from Mr. Wright, at that point, decide how we want to deal with it. Is that the best route? Or would you like to deal with it now as part of the adjournments?
I'm happy to just adjourn it, I think.
All right, so are we adjourning at sine die? That always becomes a problem. So we don't have Mr., and I guess we have no choice. We have no choice because we don't have the applicant here or the agent here to give us any guidance in terms of availability or any of that for a future hearing. So let's just adjourn this one sine die. Before we go there, is there anyone in the audience who wants to speak to an adjournment, who wants to speak to the proposal for adjournment on 762 Quanian Road? Okay, I'm not seeing anyone come forward. So based on that, committee, all those in favor of adjourning sine die? Okay, that's unanimous. We are sine die on the adjournment. Okay. And
Chair, pardon the interruption, but I would just like to add that it does require an additional variance, so a recirculation will have to take place for that one. So sine die is an appropriate adjournment in this case. Thank you.
All right, thanks so much. Okay, so we've got now our applications in order of, and we're going to start with some of the applications that are a little more straightforward. So starting with item number 4, this is for 199 Lenox Park Avenue, and I'm looking for the agent for the applicant, which is Mr. Chichetto. If I'm pronouncing that correctly, Mr. Chichetto. Yes, I see you're with us. Can you come forward, please? Good evening. So I'm going to ask you to unmute because I'm noting here that there's no sign declaration that's been provided to the committee. So bear with me. I'm going to read something to you and then I'll need you to respond. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first on the property to which the application applies, secondly, for the prescribed number of days before the hearing and prescribed under the Planning Act, and that that sign was clearly visible and legible during the entirety of that time? Do you swear that or confirm that or affirm that to be true?
I do.
Are you affirming or are you swearing that to be true?
I'm swearing that to be true.
All right, thank you so much. So with that, is it Chicchetto? Have I got that right?
Chiquetto.
Chicchetto, thank you. So the panel has had a chance to review the application and to have a discussion about it. And I'm just going to throw it out rather than ask you for a presentation. I'm going to throw it out to the committee members to ask any questions for clarification at this point. Anyone? Do you want to? Okay, I'm not seeing any questions from the committee. Do want to do one housekeeping thing with you though, Mr. Chicchetto. I understand that we are removing variance B as it's no longer required.
That's my understanding, yes.
All right. So for the record, variance B is being deleted from the application. So an approval will, the decision will only apply to the application as amended, which will be just the retention of variance A on this application. I don't see any questions from the panel on this, so I'm going to throw it out to the audience as part of the public hearing portion of this application. Is there anyone who would like to speak either for or against this application? I don't have anybody on my speakers list, but is there anybody out there who would like to speak to this application one way or the other? Okay, I'm not seeing anyone. So on that basis, committee members, then I guess I'm looking for all those in favor of granting the application. All right, so the decision is unanimous. So we have your application then is in fact approved, and I don't think there's anything else that we need to discuss, only that a tree information report will be required for the jointly owned spruce. You're aware of that comment? Mr.
Yes,
Chicchetto?
we are, and so noted.
All right. Well then, great. Thank you so much. That concludes the hearing on your application. It's granted.
Okay, very simple. Thank you, Madam Chair. Thank you, committee.
Thank you. All right. So the next one that we're going to deal with is application or item number 5 for 2001 Fairbanks Avenue. And for that one, I am looking for Mr. Poulain as the agent. Mr. Poulain, Mr. Poulain. Good evening, you are on mute. We're going to have to get you to unmute. Again,
Yeah, I'm Stéphane Pépineau. I'm here on behalf of Mr. Poulain.
Ah, okay, thank you. Merci beaucoup, Mr. Pépineau. Vous êtes confortable de procéder en anglais ou est-ce que vous voulez procéder en français? C'est comme vous voulez.
En anglais, c'est bien.
Okay, c'est bon. So the committee has had a chance to review the application. We're not going to ask for a presentation from you, but I'm going to give the members an opportunity at this point to ask any questions that they may have on your application.
Madam Chair, we do need a statutory declaration.
Ah, thank you. Thank you. I was getting good at not forgetting those. So, okay. So, Monsieur Pépineau, I'm going to read something to you because you have not submitted the, and we're getting a lot of that, so I'm not making any judgment in that regard. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was, number 1, posted on the property to which the application applies, that it was posted for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I do swear. Yeah.
All right, thank you very much. Okay, so back to questions, and I see that Mr. White, you have your hand up.
Thank you, Madam Chair. Just one question, I guess one observation more than anything. It appears to me that and correct me if I'm wrong, appears to me that the existing building does not conform to the either the setback requirement, and I'm assuming it would not conform either with respect to the rear yard area requirement. Is that correct?
That's correct.
So, Madam Chair, I'm assuming we would be dealing with the application applying to with respect to both the addition and the existing dwelling, correct? Is that reasonable?
Well, we can make the minor variance applicable to the plan, tie it to the plans, and then any changes with, so if you're worried about the ability to enlarge that sunroom or the house in any way to then essentially profit from the relief that's being granted, if we tie it to plans, as you know, that wouldn't be possible.
Yeah, I think we have to be specific with respect, because the existing dwelling does not conform. I think we have to be specific with respect to the variance applying to both the proposed addition and the existing structure.
Have we done that in the past?
Yeah.
I guess I'm looking for maybe some guidance from Mr. Hodgins.
Yeah, I mean, the application is only with respect to the addition. And I'm suggesting that it should be applicable to both the addition and the existing structure, because the existing structure is non-conforming. Now, whether you consider that to be legal non-conforming, I suppose that might apply, but I think my preference would be that the decision should reference both the existing structure and the proposed addition.
Through you, Madam Chair.
Your thoughts?
By means of varying the rear yard setback, the new rear yard setback becomes, or the required rear yard setback becomes what is identified in the notice. In this case, I think simply just tying it to plans would cover off Mr. White's concerns, so that any future deviations would have to seek further approval from the committee. I don't think the variance for the existing house isn't required, because the addition numbers in the notice are correct, and that will be the effective rear yard. So I think simply tying it to plans will cover off any ability to expand into the rear yard and other portions.
Okay. Thank you. Any other thoughts from the committee? I would have to, yes, Mr. Hindle.
Yeah, Madam Chair, I was going to suggest tying to plans anyway, especially with respect to the glazing on the rear portion of the sunroof, just to minimize the glazing facing onto the properties that would be fairly close by. But I think tying it to plans to deal with Mr. White's issue would deal with that as well.
Okay, thank you. All right, other questions about this application? All right, so now to the members of the public on this. I don't have any speakers, but is there anyone in the listening in tonight or observing who would like to speak to this application, either for or against? Okay, I'm not seeing any hands, so I'm looking back to the committee for a decision on this. All those in favor, as long as, all right, and so we're going to, Ms. Markovich, in favor? All right, so it's unanimous. The application was granted, but the decision is also tied strictly to the plans that have been provided. All right.
Understood. Thank you
And
very
I don't think there's anything else that we need to discuss. I don't see any other comments, so that's good. Thank you very much.
Thank you.
Bye now. All right, the next application that we would like to deal with is item number 6, which is for 846 and 8A and 846B Norton Avenue. Let's see, Mr. Segreto, we're back.
Yeah.
Okay, so Mr. Segreto, I need to read the same thing to you at this point, because I see we need the oath or declaration. So do you solemnly swear or affirm that the notice provided to you as part of the application and by the committee was posted on the property to which the application applies, that it was posted for the prescribed timeframe before the hearing, and that it was clearly visible and legible for the entirety of that time. Do you swear or affirm that to be true?
I swear.
All right. So in this case, again, we're not asking for a presentation. Committee's had a chance to look at it. Need though to sort of put it out to the committee members at this point. Does anybody have any questions about the application that you need to ask? Clarification at all, Mr. Hindle?
So I just wanted to confirm, Mr. Segreto, in this case, we're dealing with just parts 1 and 2 on the reference plan?
That's correct. Yeah,
Okay.
just 1 and 2, that's correct, yeah.
Okay, perfect. Thank you.
Okay.
I just want to confirm no minor variances required. It's completely in compliance with the zoning bylaw.
That's correct.
I also just, I noticed there's a bit of a discrepancy in the notice and your submission on November 2020. You said that it's, that you need to demolish the existing building. Is it already demolished, Mr. Segreto?
Yes, it is.
It is, okay. So your letter just didn't catch up maybe with the description in the notice? Okay, but it is demolished, okay?
It is, yes.
And it's under construction? It didn't quite marry up together in the wording, so that's good. All right, any other questions? All right, out to the public, anyone in the audience who has an interest in this application, would you like to address the committee either for or against? This is your opportunity. Okay, I'm not seeing anyone, so with that, all those in favor of the application? All right, so for the record, that's a unanimous granting or approval from all of the members. Mr. Segreto, there's a number of different conditions. You are aware of them?
I'm aware of the cash in lieu. There's 5 conditions. I think there's 3 conditions there, and I think we're okay with all 3 of them, yes.
You have a party wall, hydro easement, cash in lieu, independent services.
It's all standard stuff. That's fairly straightforward. That's fine.
As long as you're aware and if you and you're good with that, because the application is subject to those conditions. All right. Okay. Well, thank you very much, then, Mr. Segreto. We're done. I think you're done for the evening. You're early.
Thank you.
Good change. All right. Thank you. Okay, we're on to item number 8, which is 1749 and 1751 Baseline Road. And I am looking for Ms. Watts, agent for the applicant. And I see that you're there, so if you can come forward, that would be great.
The host has asked you to start your video. Okay.
Okay.
Hi.
Hello.
Hello.
All right. Okay, and so who's with you then? So who's Lorna?
I'm Lorna.
All right.
I'm the power of attorney, and this is my daughter who's been looking after things.
All right, can we just for the record have your daughter's name and the and where she resides?
Shani, S-H-A-N-I, Guerin, G-U-E-R-I-N, in Ottawa, 1227 Prince of Wales.
All right, perfect. Thank you very much. That's we need that for the record to see who, so that we have a good account of who's presenting with or appearing. So I do need to also get a statutory declaration from you. So I'm not sure which of you ladies is going to respond. I'm going to read this out, and I'm looking probably from you, Ms. Watt, if you wouldn't mind. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was posted, thank you, that it was posted for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Okay, and it was clearly visible and legible for the entirety of that time?
Yes.
Okay, so do you solemnly swear and confirm all of that to be true?
I swear, solemnly.
All right. Okay, thank you very much. We need to get that for the record. It's part of the requirements of the process. So so we're good. Okay, so we're not going to ask for a presentation because again, the committee has had a chance to go through your application and we've reviewed it. We've had a chance to discuss it. Just at this point, I'm going to open it up to the committee members to see whether or not they have any questions for the agent on this. So, okay, I'm not seeing any questions on it. All right, so that being the case, I don't have anybody on my speakers list, but I'm going to open it up. Is there anyone who is participating this evening or in the audience want to approach or speak to the panel either for or against this application? Okay, I'm not seeing anyone. So in that case, committee, I guess I'm looking for all those in favor of granting the application. All right, thank you. So it's a unanimous with the panel that we are granting the application. The only thing I would like to just go over with you quickly is the conditions that will apply. Have you had a chance to look at those? You understand what the a number of them here. I just wanted to be available to ask any questions if you had any questions about them, or
You want to ask about the firewall?
The firewall, we were just trying to figure out exactly how to do that. Is it that we need to get an architect in to make sure that the firewall in the basements is up to the code now?
I will admit that's kind of out of my expertise. So Mr. Hodgins, can you provide some direction in that regard?
Through you, Madam Chair, I do believe it is a architect or an engineer who needs to provide that certification. If the applicant wishes to reach out to me, I can put them in touch with the building inspector who would be looking after that, and they can provide further direction on what exactly will be required to clear that condition.
Perfect.
That's perfect. Thank you. Thank you very much. Well, thank you very much, ladies, for participating this evening.
Okay, thank you.
All right, bye now. Okay, the next application that we have is item number 9, and it's for 541 Burleigh Place. And I am looking for, as the agent, Mr. Holtzman.
Hello, Madam Chair, members of the committee. I am Bill Holzman. I may have some challenges with my internet, so if I find that it's freezing up, I'll take my picture off there and just continue with my my verbal presentation. Okay.
All right, that's fine. So the committee has had a chance to look at this this application. There's a lot going on, but it was still an interesting application to review. Any questions? Does the members, does anybody need any clarification on any aspect?
Sorry, Madam Chair, we need the sworn.
That's right.
Thank you. Thank you.
Thank you.
I guess it must be the first of the year, first meeting of the year. Got to get back in the role. It's been too much of a break.
You're definitely excused.
Mr. Holtzman, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you swear or affirm that to be true?
Yes, I affirm that to be true.
All right, thank you. Okay, back to some questions by the committee. No? I have just one for clarification, to be honest with you, I guess. So it's a 2-story addition to an existing 3-story semi-detached, is that correct?
That's correct.
And so we're talking about a second-story deck. Is that it in terms of really what the permission is?
No, part of the addition protrudes into what would be a typical rear yard, but as you may recall, and Lucy did a wonderful job in her staff report to explain the issues of the legal non-conforming. So we're looking for that relief to the rear yard, but it's permission because it's a legal non-conforming use.
Okay.
It's an extension of a legal non-conforming use.
All right, thank you. Okay. Mr. White, I see you have your hand up.
Yes, Madam Chair. Just a question of staff. I noticed that in the report that this refers to site plan control. I guess it might have been granted under the old home rules just shortly after amalgamation. First of all, is there a site plan agreement associated with this development? Second, if that is the case, does this require or generate a requirement for an amendment to the existing site plan agreement?
Through you, Madam Chair, yes, there is a site plan agreement registered on the lot. I provided that information just to provide information that the uses were legally established. The zoning, was under, yes, it was under previous bylaw for Gloucester. And when the cities, and from my understanding, this was because one side was a semi-detached, the other side was a duplex. It was considered an apartment building. And so the rear yard setback is what the addition is being expanded into, which would be the zoning.
So just follow up, Madam Chair. If there's a site plan agreement on registered on title, is this required to be amended? That agreement, is there an amendment to the site plan, approved site plan required here? Or is it of such a nature that it doesn't generate requirement for amendment to that agreement?
Through you, Madam Chair, I don't see how this would require an amendment. This addition would require an amendment to the site plan agreement that's registered on title.
Madam Chair, Mr. Holtzman has a comment.
Yep. Yes,
if I could, if it does, it would be picked up at the building permit stage. And if we have to, which I strongly feel that we won't have to based on the reading of the site plan control bylaw, that we would have to go through SPA. So I don't think it's really it's an interesting point. I'm not sure that it has, hopefully has no bearing on your decision tonight, positive or negative. But if we have to, we have to, but I can't imagine that the city will require us to go through SPA for this.
Madam Chair, my only concern is if there is an amendment required, then the parties to the agreement would have to be parties to the application, which means that anyone that lives in a unit that's subject to this site plan agreement would have to be party to that application. So hopefully that's not the case, but I just bring it up for information that that may be an issue.
So, Mr. White, what would you suggest might give you that comfort then, if we were to, and again, we would have to then adjourn and get that information. But what do you think you would need in order to get that?
Madam Chair, I think Mr. Holtzman's correct. I don't think it really affects our decision ability to make a decision, because there is another, if there is a site plan agreement that has to be dealt with, that's another approval issue, another approval process that has to be gone through. That is outside of our jurisdiction.
Yeah, but it does. Okay, but it does raise, how we tend to like the first process to kind of resolve itself before we get into minor variances. But that's fine. I just wanted to make sure that there wasn't some other solution that you might be proposing here. And if you don't think we need one, then that's good too.
No, I've just been doing this long enough to know that these kind of things can create problems. And if this was a semi-detached on an individual owned property, it wouldn't be that would not be an issue. But being that it's on a development approval subject to site plan control at one point in time, and there is an agreement that's registered on title that is everybody who owns a unit in there is party to that agreement. If there's an amendment required, or somebody decides that there's an amendment required, it could be an issue.
Melissa, so you had your hand up?
Well, I was just going to, I think Ms. Ramirez and Mr. Holtzman have both said that it's not required pursuant to the site plan control agreement, which is quite specific about you need to have 10 more parking spaces, and it talks about the size of any addition that's required in the site plan in order to have to go through that process again. So I think in this instance that it's pretty clear that site plan approval is not required.
Okay, thank you. I appreciate that. All right. In that case, If there's no other questions by the committee, I'm going to go to the public portion on this application. We don't have anyone on the speakers list, so if there's anyone who's participating this evening, part of the audience, and you'd like to provide comments to the committee about this application, either for or against, now would be your chance. All right, I'm not seeing any hands raised. Got to give it a minute, give people a chance to react. Technology can be slow, so, but I don't see anyone there. So based on that, then committee, all those in favor of the application? All right, okay, so Mr. Holtzman, I think you're seeing a unanimous granting of the application at this point. So, so it was an interesting one to deal with. So thanks for bringing that forward.
Okay, thank you very much, and have a good evening.
So you too. Have a great evening. All right, I believe I wonder if we're done our fast tracking. Just give me 2 seconds here. All right. Okay. Nope. We're going to go now to application number 1 and 2. And I believe, just bear with me. I have a lot of paper tonight to deal with. So applications 1 and 2 for 4345 McKenna Casey, and I believe, yes, Miss Brennan. What did I miss?
Madam Chair, I believe we have a Qualicum application number 13. It was a number 13 on the.
Right, we do have that one. Just a minute, let me catch up. Yeah, okay, and you're right. This is a fast track one too, so we'll deal with it too. My apologies on the item 1 and 2. We'll come back to that in just a minute. So, so I guess on item 13, the applicant or the agent is Mr. Chadwick. Mr. Chadwick, are you there? I do see that you're there. Okay. Good evening. So, Mr. Chadwick, I'm going to need to read something.
I'm here.
Hello. I'm going to need you to respond to something for me, right? Because we're looking for a statutory declaration for the sign posting, which we don't have. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was first posted on the property, that's the subject of the application, for the prescribed number of days before the hearing, and that it was clearly visible and legible for the entirety of that time? Do you swear or affirm that to be true?
Yes, I'm confirming now.
Okay, so you affirm that to be true? Okay, good. All right, we're not going to ask for a presentation from you on this. That said, we're going to go directly to, just before we get to questions by the committee, there is a housekeeping amendment to your notice. So my understanding is that in terms of the lot area, I'm going back here. So the lot area,
Payments?
it's just a modification, So so if I understand things correctly, the part 3 will have a frontage of 21.58 meters on an irregular depth and a regular depth of 89.7 meters, and will contain an area of approximately, and it should be 4,220.9 square meters. Is that correct?
That's
Yes?
correct.
All right, thank you. Okay, that was the only housekeeping amendment that I could see was required.
Madam Chair, if I may. So my name is Andrew Bales. I'm the purchaser. I'm Mr. Chadwick's neighbour. So I'm planning to purchase the land here. What we were talking about adjusting the application to being a lot line adjustment rather than a severance. That's the only thing I wanted to say up front.
Yes, that's fine. So the nature of the application is a consent. A consent can be for a number of different things, including a lot line adjustment. Okay. So that's fine. We were aware that that's what it is. So, you know, in the description, it's pretty clear that it's essentially conveying a portion of the property to the property next to it. So, so thanks for that. We do, we did review it with that in mind. Okay. So committee, right, we're not asking for a presentation. Ms. Willis, do you have a question?
I do. I have a question really for staff on this, and I think it might be addressed, just the comment that was made that this is to be a lot line adjustment. But we often see, at least I'm not clear on when we see a condition and when we don't see the condition that specifically states that this block has to be conveyed to the adjacent property owner. I don't see that as a condition here, so I'm just wondering whether it's appropriate to include it or whether making this a lot line adjustment deals with that issue.
Right, Mr. Hodgins.
Through you, Madam Chair, the condition in reference is typically imposed directly by the Committee of Adjustment. Is standard for lot line adjustments. So possibly the Secretary Treasurer can confirm, but the Planning, Infrastructure and Economic Development Department doesn't typically request that simply because it's standard for lot line adjustments by the committee.
All right, Ms. Brennan, can you confirm that for us, please?
I can confirm that, Madam Chair. We do put that condition on, and as a matter of standard practice with a 5012 condition of the Planning Act.
Stipulation.
So just to make sure I understand this. So the fact that it's being changed from a straight consent to a lot line adjustment, and I assume then it wasn't shown that way on the application form, that will be changed in order for you to have the authority to put that condition on because it's a lot line adjustment?
Madam Chair, through you, the application would have indicated that on the page. However, the notice would still read as it currently reads.
Okay.
I have to admit, Ms. Willis, that I didn't interpret that way either, that it would be in any way restrictive. Okay, all right. Well, I'm glad we got that clarification though. That's a good part. I guess the only other thing I was interested in, I think I read somewhere in this package that in fact it did actually run with the property originally. Mr. Bayless, is that true? Was that actually part of that property at some point?
I purchased this property 5 months ago, and I've been in conversation with Mr. Chadwick since I moved here. The property in question is the other side of the creek from Mr. Chadwick's house, and it is only about 6 feet from my house. I don't know the history, unfortunately. I appreciate it.
Oh no, okay. I thought I'd seen that. Mr. Chadwick, do you have the history on that? Was it always part of your property?
Actually, the creek acts as a barrier to my accessing the property that I owned on the other side, which is sold to Mr. Bales. And it's natural for that property to be part of his holding than mine, because the barrier is the creek and I don't have access to the other side.
Well, it makes total sense. I mean, I think this is something that, you know, I've never seen anything so logical, I think, in terms of lot line adjustments. It's kind of an obvious one. So excellent. Mr. Hodgins, did you have something you wanted to add?
Well, just through you, Madam Chair, I just thought I'd point out, I do believe they were at one point in the ownership of the other parcel, a portion. It's difficult to tell on the plans. There's little information available, but it does look like on the 4R plan that the lot was larger, including portions of the other side of the creek, as was the adjacent property. When the transfer happened, I'm not sure, but I do believe a portion of the property was in the ownership originally.
All right, thank you. I began to think maybe I'd been dreaming that part or something after seeing so many applications go. Okay, any other? Oh, I guess there's just one other housekeeping change to the notice. I just, so my apologies. But I guess we're reading the severed land shown as part of 1 and 2 on draft 4R plan. We're striking out the words will be landlocked. So just making that, reading into that record to make sure that the notice is amended in that regard. Okay, no follow-on questions here from the committee? All right. I don't, again, have anyone to speak to this application. So is there anyone in the audience who would like to speak either for or against this application? All right, and I'm not seeing anyone. So on that basis, then committee, all those in favor? All right, so for the record, the decision is unanimous. So thank you, gentlemen, for appearing this evening. Your application is granted.
Thank you, Madam Chair. Thank you.
Thank you, Ms. Tremblay.
All right, thank you. Have a nice evening. All right, we're back to applications or items 1 and 2 for McKenna Casey Drive. So, and on that we've got, back to my list here. So I think we're looking for, is it going to be Mr. Alain or Ms. Carrera?
Hi, Madam Chair. I'm here on behalf of the application. Ms. Carrera is also present from FOTEN. I'm from FOTEN as well. And then the client, Hugo Lalonde, I believe is also present. And he'll be taking the oath actually, as he was the one who put up the signs.
All right, so can we have you come forward, Mr. Lalonde? Yes. I'm going to read this to you and I will need you to respond. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted on the property to which the application applies, that it was posted for the prescribed number of days prior to the hearing, and that it was clearly legible and visible during the entirety of that time? Do you either swear or affirm that to be true?
I do, Madam Chair.
Do you swear?
Swear it to be true. Thank you.
All right, thanks so much. Okay, Mr. Alain, we will be looking for a presentation on both the consent and the minor variance, obviously together.
Yep.
So the floor is yours. Go ahead, please.
Thank you, Madam Chair. If the coordinator can please bring up our slide package, that would be fantastic. And I'll let you know when I would like you to change them, if that's all right with you. Perfect, I see them now. So as introduced, FOTEN has been retained by Barrhaven Conservancy Development Corporation to submit these reciprocal consent applications, as well as a minor variance application for the subject lands. The lands are, and you can switch to the next slide, please. They are 4375 McKenna Casey, 4305 McKenna Casey, 4345 McKenna Casey, and then 3288 Boris O'Kane Road and 3300 Boris O'Kane Road. So they represent a total of 86 hectares. As you can see, they are along the Jock River and adjacent to Highway 416. So just a quick history, the lands have been used continuously for agricultural purposes for a long while. However, in 2020, as part of an earthworks program to alter the floodline along the Jock River, the agricultural uses have stopped on the site. Next slide, please. So the primary purpose of these consents is to sever the land into 2 holdings. So of the 5 properties, we're looking to have them as land group A, which would be 4345 and 4375 McKenna Casey. I'll show you in just a moment a graphic to help visualize what this looks like. And land group B, which will be 4305 McKenna Casey, 3288 and 3300. All of these properties were originally separate and indeed have their own individual pins. However, they merged on title when the ownership was transferred. Next slide, please. So you'll note the orange line that demarcates the 2 land groups. So there's a western portion that's supposed to be severed from the eastern portion. And you can go to the next slide, please. So again, this is the same representation just shown on the draft plan. So parts 1 and 3 will be in land group A, and parts 2, 4, and 5 will be in land group B. Next slide, please. I'll add, well, I'm actually, yeah, this is fine. You don't have to go back. So just as a note, concurrent plan of subdivision and zoning bylaw applications for the remainder of the subject lands, including, that's actually all the, sorry, I confused myself. So the eastern ends of parts 4 and 5, so that's the portion which actually, if you go back to 2 slides previous, apologies. Perfect. So just to show more clearly, so land group B, There's an active plan of subdivision application, which involves the eastern ends of these properties called the Conservancy, which we can pull up the plan later if desired for that. And the remainder of the properties, that being all the properties under discussion today, will eventually be part of a forthcoming application for a western portion of the same subdivision. Now, if I can move on to speak about the variances we're requesting, if the coordinator can please go to the previous slide we were at. So I think it's 6. Perfect. So we're requesting variances to section 59, and in particular 3 sections of section 59. So these variances refer to land group A, which will, following the severances if granted, not have frontage on a public street. So all 3 of these refer to the bylaw provisions related to not having frontage on a public street. So the first one states that no person shall develop a lot unless it has 3 meters of frontage. The second states no person shall sever any land unless both the land severed and retained abuts a street, per the first section. And the third just notes that when there's multiple lots involved, more than 2, then the same applies. And the broad variance we're requesting is to permit a lot that abuts a public improved street for 0 meters to be severed. I can go through the 4 tests at this time if the committee desires.
Yes, please do. Run us through the tests.
Great. Okay. So the first test, of course, is whether the variance is minor. So I'll note that this is a pre-existing condition that we are trying to restore, and it's technical in the sense that no long-term impacts are anticipated for the lands being discussed or adjacent lands. Any future development of the subject lands, that being those which will have no frontage, will have to meet section 59. And that is further exacerbated by the fact that there are development review lands, DR, in the zoning, meaning that additionally a zoning bylaw amendment would be required for any development of the lands. Secondly, the second test is whether it's desirable. So it's been viewed as desirable because it allows for flexibility in the development of these lands. As noted before, land group B is partially subject to a current plan of subdivision application, and therefore the future intended residential development of these lands is easier facilitated. I'll note that, and we can also refer to these slides if desired, the OP designation is general urban area, except for the frontage along the Jock River, which is open space. And that brings us to the third test, which is the intent and purpose of the zoning bylaw. So of course, the intent of section 59 is to avoid the development of property that does not have frontage on a public roadway. This intent is being held up because any future development of this property will require a zoning bylaw amendment application or otherwise to meet section 59. And it is only the severance in this case that actually necessitates the application of this variance we are requesting. And lastly, the test is to maintain the general intent and purpose of the official plan. So as noted previously, the lands are primarily general urban area, and general urban area as a policy group does not, or as a list of policies does not make any note on severances specifically. However, the intent of the official plan to establish residential development and of course, general urban area also allows a mix of use, including commercials, et cetera, are supported by the severance, which allows the further facilitation of this. Next slide, please, which this slide, further than the test, also just gives a little bit more rationale on the variances. So there's a section 4 to section 59, which would have previously applied, which refers to continuous agricultural uses being allowed for severances without frontage. The recent site works to alter the floodplain along the Jock River disqualify it from this provision. second point here. There is no development proposed for land group A at this time. And given the development reserve zoning, a zoning bylaw amendment would be required to permit any development. And I'll note that development is anticipated through future phases of the subdivision under contemplation right now. And at that time, it'll have to meet the test. It's also noted that the public improved streets arising from the subdivisions on land group B and forthcoming to land group A will provide frontage to these parcels at that time. And in the interim, the minor variance being proposed is to reestablish the existing condition, simply such that the properties can be managed independently in the interim. Next slide, please. These slides are referential in nature. I could go through them if you wish, but if you're satisfied with just hearing about the test and the rationale, then I can allow for questions and comments.
All right, thank you very much, Mr. Ading. All right, so I am a little remiss here. We have some housekeeping amendments that are required to the notice, if I've understood things correctly. So in fact, we need to make reference under the B00245 to, rather than 24.7 hectares, to 24.66 hectares. Is that correct?
That's right.
All right, thank you. And for B00244, we're looking at an irregular size of 61.51 hectares rather than the 24.7. Is that correct?
That's correct.
All right. Okay. So duly noted for the record, we have amended the notice to read that way. Now, okay. Questions from the committee? I'm sure there are some. Mr. Hindle.
Thank you, Madam Chair. I think, Monsieur Alain, my question in this case is really about access. That's my major concern. And I understand that the plan is for it to build out over time, but I imagine that will take years, if not a decade or longer, to get there. So what is the plan for access to the land group A along the highway in the interim?
So as noted, this is an interim condition, and through you, Madam Chair, I agree with that. The fact of the matter is that this is a pre-existing condition, and there's no intent to utilize the land for prior to its. Sorry, I'm just hearing myself all over my voice a bit. There's no intent to have any prior need to access the land besides for any maintenance uses before the development takes place.
So I think that's where I start to have a bit of a concern, because we've dealt with this similar issue on other applications fairly recently before this panel. I'm concerned that there would be no legal right of access to the land group A without us intervening effectively. So if we approve this minor variance as is, there's no legal right of access to this property, which to me is quite problematic. You know, I think there are scenarios very easily conceivable where you'd either want to do further earthworks or start works, or even just for bylaw standards maintenance to go in and access that property. And right now we have access to those two properties via the other properties that then have access off of McKenna-Casey or in other directions. So is there a scenario in this case where adding an access easement of some kind would be problematic to the development process? Because I think that's fairly standard in my experience.
If I could answer that, I just wanted to point out that Barrhaven Conservancy Development Corporation, who are developing this conservancy subdivision in phases, even though we're asking for these lands to be separated into two groups, they're still retaining ownership of these lands. They're not being sold to anyone else. It's simply a matter of they purchased these 5 lots, accidentally got put in the same name, they merged on title, and for various business reasons that I don't know all the details of, they need them separated back out because it is a phased development. As Scott mentioned, they've already submitted draft plan and zoning applications for the eastern end of the 2 lots that abut Boris O'Kane. And the application for the rest of all of the lands is expected to be submitted within a month. So this development is moving forward. The approvals are moving forward. Obviously, the actual development will take time, but there are plans to continue with planning these roads that will provide access. But in the meantime, they'll all still technically be under control of the same person. I don't know, Hugo, do you have anything to add?
Yeah, I think that's fair. I think my concern is that by creating two separate titles, that doesn't mean that condition is going to continue. There could easily be a sale of the western portion to someone else, and then all of a sudden that access, and I've seen it happen. Business relationships break down, and then all of a sudden people get vindictive, and then we run into issues over time. So I think my concern and what the outcome that I think prefer to see is some kind of an access easement, whether it's a blanket easement or an addition of a part, even on the existing access that it looks like comes off of McKenna-Casey, just to create a small piece of access in this scenario, so that I acknowledge that it used to be in this scenario, but it merged, and I think now is the time to do it properly so that we don't create further issues when we have the chance to rectify them.
Just
all right. Okay. So did you want to respond to Mr. Hindle? Because I'd like to move on to Mr. White at this point then.
It's up to you. I was just going to consult with the property owner to see what their thoughts are on that access easement, but we can continue questions.
Yeah. So how about we, so we've kind of explored that. I'd like to get to the committee members, and then we'll come back, and then we can speak with Mr. Lalonde after that, and we can explore some of the options. Mr. White, please.
Thank you, Madam Chair. I guess I'm sort of following up on what Mr. Hindle's concern relates to. I'd like to know a little more about the severance history, the land acquisition history of these lands, because my experience in this area, as far as I am aware, these lands that are, I guess, referred to the ones adjacent to the Highway 416 corridor. And perhaps the applicant can correct me if I'm wrong, but my understanding is that those lands were originally acquired by the Ministry of Transportation of Ontario as part of the acquisition of the 416 right-of-way. They were landlocked because they cut off frontage to the street that's long since been closed on the west side. So I'm curious, what I would suspect has happened here is that these lands have been acquired from the Highway Authority. They were consolidated with lands that were owned by the current owner of the lands to the east, and they consolidated with them with the intent of being developed as a comprehensive future subdivision or whatever. And on that basis, I have some difficulty understanding how eliminating the consolidation, in other words, going back to a ownership situation that did not exist in the past. MTO, in fact, did own those lands, and the MTO had control of them. They had access, obviously, via the highway right of way. So really, if that's the situation, if that's how the acquisitions happen, then we're really making a situation that did not exist in the past. We're creating a new situation of creating landlocked parcels. Maybe somebody can correct me if I'm wrong in my understanding of the history of those parcels to the west.
All right, thank you, Mr. White. I had sort of the same questions, to be honest with you. So who from your team then, Mr. Alain, would be best positioned to give us that history?
I believe Mr. Lalonde would have the most knowledge of the property ownership history.
All right, thank you very much. Monsieur Lalonde.
Yes, thank you all. Can you all hear me okay?
Yes.
Thank you. So indeed, we're seeking a severance to separate the two parcels that would form Land Group A from the rest of the holdings. These properties were acquired by Kaivan under the Barrhaven Conservancy Corporation company over a period of time, and they were bought from the original landowners. And so Mr. White is correct, in fact, that the most western lands were cut off from Moody Drive further to the west through the 416 expropriation process in the 90s. However, the Bruce parcel, which is shown as part 2 on our reference plan, was bought in 2018. The Casey parcel, part 1, in 2019. The Brophy parcel, part 3, in 2019. And parts 4 and 5 in 2017 from a different individual as well. And through, you know, in careful planning perhaps on our part, they were all registered under the same corporate entity and have since merged title. Never at one point in our ownership did they ever have frontage. In fact, parts 1 and 2, if I'm correct here, I'm just going to go back to my plan. Part 1 does not have frontage and was a separate party part prior to our purchase. Part 2 also does not have frontage on McKinney-Casey. There's a CN railway that restricts access to McKinney-Casey. And there's a city property that is a slim wedge in between the railway and part 2, which also prevents access. So when we purchased these properties, in addition to part number 3, being the Brophy parcel closest to the Jock River along the 416, there was no frontage whatsoever. And so we haven't created this situation. It was purchased that way. And unfortunately, through merger of title, that's created some issues for us. So we are seeking a consent to separate these two land holdings into different entities. With regards to development of the lands, certainly we have a draft plan application in the door currently with the City of Ottawa for parts of the eastern lands that have frontage on Bourse O'Kane. That draft plan has some road stubs that are proposed to extend westerly into what would be the remnant lands that are not part of the subdivision, but will be very shortly through another application. The timing and horizon rather for the development of the western lands, I don't think is a decade or 5 years. We could very well see some development there within the next few years. The intent is not to sell that land. The intent is to maintain that land within Kaivan ownership. And we did not think that an access easement would be required simply because we're just simply reinstating parcels that were separate entities prior to our purchase. If it is the committee's decision that an easement is required or something of the like, we can certainly entertain that, but we didn't deem it to be necessary at the time of our application.
All right, thank you, Mr. Ledon. Mr. White, I see you have your hand up.
Thank you, Madam Chair. Could I follow-up question to staff? I know that they've expressed some concerns in their report with respect to the nonconformity with the lot frontage or access to a maintained public street. But I'm wondering what their views might be on how does this redivision of these lands really promote the good planning that would be going into a comprehensive plan subdivision process involving all of the lands. I'm struggling with that principle that this represents good planning from a future planning subdivision process point of view.
All right, thank you, Mr. White. Mr. Hodgins.
Thank you, Madam Chair, through you. Mr. White, I hope if I answer your question. If not, please feel free to follow up. I think through the city's perspective, it's clear that these lands will develop over time into some sort of subdivision. I think that if the road stubbed at the landlocked parcel, we would have had less issue with that under the draft plan currently. But the reality is that the draft plan at this time only goes to, I referenced a creek, but really it lines up approximately with
Sorry, Mr. Hodgins, we've just lost you a little bit there. Repeat what you said, please.
Yes. Let me know if I cut out again. But through the city's perspective, I think that we anticipate these lands will develop over time. The issue is that under the current draft plan of subdivision, the streets are stubbed a couple hundred meters from the proposed landlocked parcels, and we don't know how it will develop through a subsequent phase. As noted in the report, there is a secondary plan for this area, which does intend the lands for development. It is zoned development reserve, so residential development is likely intended for these lands. And there is an ongoing application to revise the floodplain boundaries. So the city does anticipate that these lands will develop in the future. Our concerns are really that the distance from a roadway is a couple hundred meters away at this point, and we don't know how the future subdivision will propose access to the landlocked parcel. Mr. White, if you have any follow-up questions, please let me know.
All right. Okay.
Madam Chair, I could ask a lot of questions about how we got here in terms of the official plan designations and all that sort of thing, but I think that's water under the bridge. My recollection was these lands were always in a limited development type of designation, and I noticed that there's obviously been amendments to the secondary plan that put them in a residential, or portion of them in a residential designation, but that's probably related to some official plan work that's gone on. But I'm still having difficulty understanding how a division of land in this kind of situation would make a parcel like this more planning appropriate or more appropriate to future planning than a proper consolidation in a ownership situation that we have today. It's a lot easier. I know basic principle of planning is you promote land consolidation. You don't promote land division where future development is the objective. Integrated future development is the objective. But I mean, that's my issue.
All right, thank you, Mr. White. Ms. Willis, please.
I have a couple of questions. I agree with what Mr. Hindle has been saying, and I think Mr. White, just my concern is legal access to land that doesn't have access, because even though the intention of KBAN is to keep it in their own ownership, it doesn't prevent a sale to another party at a future date. So I'm wondering, first of all, why, without wanting to delay things, why is it desirable for the company to go back into this pattern of ownership when you could, I mean, there's probably a reason why you're not just putting a plan of subdivision on the entire property and just identifying those two pieces as separate blocks, and you could come and re-subdivide them at some point in future, which would deal with the access issue, because it's all under one ownership. And then if you're doing a subdivision agreement, you'd have to deal with transfer to a third party dealing with access and that sort of thing. So I'm wondering if somebody can explain why this is necessary at this point in time.
All right, thank you, Ms. Willis. I think you're expressing some, obviously there's a common thread that's occurring across the committee here. Mr. Lalonde, did you want to respond to that?
Yes, thank you. Through you, Madam Chair. Our main driver here for seeking this consent is for financial purposes for development of these lands. There are opportunities that are afforded to us by having separate entities for financing for development purposes, and this is our main requirement here. I also wanted to add that, well, perhaps to Ms. Willis's question, so this is a complex piece of property to develop. As Mr. White noted, it was formerly in the floodplain, and it was formerly designated as recreational, commercial in the old secondary plan. There's a long history here in terms of amending the secondary plan. We undertook an extensive earth moving program, did a cut along the Jock River to make these lands developable, and moved an enormous amount of dirt to these lands to bring them outside of the floodplain. As part of that earthworks exercise, we did build some construction roads from Bourse-O'Kane onto what would be the landlocked parcels that we are seeking today, as well as from McKinney-Casey onto the landlocked parcels. So there is a means of access today. It's not a formal one, it's not a legal one, but it is one that we are under control and managing ourselves. So that's what I wanted to add. I don't know if there's any other specific questions that I can help with the committee, but please feel free to ask.
All right, thank you, Mr. Lalonde. Okay, so I'm not seeing any other questions from the committee at this point, so I'm going to open it up to the public. Again, I don't have anyone on my speakers list, but is there anyone in the audience who would like to speak either for or against this application? All right. I'm not seeing any hands or any movement on the screen. So with that, I think we're back to the committee then for consideration of the consent and minor variance applications. So I think I heard, I'm going to go out on a limb here. I think I heard from the committee that we're still not convinced that we've heard enough evidence to demonstrate that this is in fact orderly development. And we haven't heard, at least from my perspective, enough argument or rationale to indicate why we would move forward, or why there's a need to move forward with the consent application at this particular point in time. We haven't really heard, other than Mr. Lalonde saying at one point that he would be willing, if need be, to put in an access easement. But I think overall, I think Mr. White probably summarized it the best, and that is that at the end of the day, the development, even though we know that it's a development reserve designation and that zoning, and that they'll have to move forward with, well, I guess it's a designation and it's a zoning you'll have to move forward with. Sorry, it's getting late. I guess all this to say that the committee may not be in favor of the consent application or the minor variance. So I think I'd like a show of hands for those who would be opposed to this application at this point. All right, Ms. Willis, opposed? Mr. Hindle?
No. I just wanted a question for you. My only hang-up is access to the landlocked property. So I'm okay with proceeding if we can condition it in a manner that requires access to the landlocked parcels, either by adjourning it and they come back with an R plan, or by putting a detailed condition in saying that they have to satisfy that there's going to be access to from a public street to the landlocked parcels. Then I'm okay with proceeding with this application, but only if there's access afforded in some way.
Yeah, I would agree with that approach, whether it's a blanket easement or we adjourn and we come back with an R plan that shows a part with a specific easement. And then, yeah, just conditioning it to figure out the language. I'm comfortable with that.
To be honest with you, I think at this point, if we're going that direction, a blanket easement is probably the best approach, but I would probably rely on Mr. Hodgins' advice on that as well. Ms. Markovich, I haven't heard from you.
Yeah, sorry, I was going to say if that's the possibility of a blanket easement to introduce that, I think I would support that decision. When you asked us previously about our stand on this, I thought you were mentioning the application as is. I could not accept that, but I could work with this other solution.
All right, thank you, Ms. Markovich.
Madam Chair?
Yes.
Yeah, I mean, that's not in terms of the good planning approach, that's not the best planning approach. However, it is and I think the rest of the committee will likely agree with me on that. It's not the best approach to planning development of lands of this type. Your land development, consolidation of lands is a lot better, a lot easier tool to ensure that good planning is carried out. However, if we can get into a situation where the lands are linked, at least in terms of providing connection, access purposes, that sort of thing, I'd be inclined to support that approach.
All right, thank you, Mr. White. I'm going to ask Mr. Lalonde a question, actually, just go back, because I'm still a little uncomfortable because I don't think I've heard enough evidence to really convince me. Even though we're, there is, and I appreciate the comments that Mr. White made, I still don't think I've heard quite the rationale yet. But just going back to I almost lost my train of thought there. In terms of the manner in which you need to proceed. So you made the argument that part of the reason why you really need this to happen is actually for financial reasons. And what the committee sees often is not severances in the sense that we're actually going to redivide the titles, but rather that we do severances for mortgage charge purposes, which is completely an option under the Planning Act. Had you thought about doing that instead, rather than specifically doing the consent for the titles, just do a mortgage charge severance?
That did come to mind. However, without getting into all the specific details of our business operations, we have partners on this development, and it's just the preferred way forward for us is to have a separate entity on which equity can be drawn from that doesn't affect another partner. And so without getting into the specifics, that's kind of the gist of it. And we were advised through our lawyer that this was the preferred approach to resolve the situation.
All right, I think I did do a call out to the public hearing, did I not? Somebody just remind me. Yes, thank you. Again, it is getting a little late. So, all right, so on that basis, then I do need to know who's in, so I need all in favor of the consents.
I think, Madam Chair, I think we want to hear from the applicant as to how they want to proceed related to access in this case.
Well, all right, so I guess I thought I heard Mr. Lalonde actually agree that he would provide, he was open to providing an easement. I was going to simply propose that we add as that condition the blanket easement. And I think, Mr. Hodgins, there's wording that we can draw on that we've used in the past that's fairly generic that we can apply here. Is that correct?
Through you, Madam Chair, I'm not sure the blanket easement language I have seen frequently in the past. Personally, I would likely defer to the applicant on how they would want to proceed here. I don't know how the implications or what the implications would be on their ongoing plan of subdivision with a blanket easement being placed on the land. So personally, I don't know all the impacts and I don't have the wording in front of me. But we could likely work something out with the applicant if that's how they want to proceed.
Right, so Mr. Lalonde, the difference in my mind between a blanket easement and one that has parts is one of time. So if we're looking at different parts, we'll need an R plan, we'll need to come back, we'll need to adjourn in order for all that to happen. If we rely on language that we've used in the past, which is really to say, we're giving a blanket easement from part one, so the parts, so we'd have to get the parts right. So, and I think, I think I'm going to leave it to staff to come back with all of that. But I think that generally speaking, I don't want to say that it's simple. It's never simple, but it's easier, I guess. It's less complicated than trying to do, I'm trying to figure something else out this evening, and we can't, obviously, unless we have an R plan anyway. So, but I think we can say that there is a blanket easement in favor of parts X, Y, and Z, and then it's reciprocal, and then you wind up, I think, again, I'm kind of looking for guidance on this, but I think that's kind of how it happens. And I think we can move forward with an approval with the condition, with enough direction that condition be worded to the satisfaction of, and I'm going to say at this point, the committee staff and PED together. And again, I'm kind of looking for some guidance here, but I think we can make it happen in a way, right? That's pretty clear.
Yeah, and I would be open to that. I don't have an issue with a condition for a blanket easement. As I said, we are managing the entire land holding, regardless of the severance, and would handle that easement internally going forward. So there's no problem with what's being suggested, Madam Chair.
Mr. Hodgins, just need some advice. So is that a condition that you can maybe put together for us? I'm not gonna hold you to a thought, but that you can provide within the next few days for review by the applicants to make sure they're okay with the wording, and as long as we're good to go, and committee staff, obviously. And if everyone's in agreement, then we proceed. If we're not all in agreement, then it comes back to us.
Yes, through you, Madam Chair, I can definitely work with legal services and get some draft wording for the applicant and the committee to review.
Writing, have you got any concerns or any comments you want to add at this point?
Not at this point, Madam Chair.
All right, thank you very much. Okay, I'm going to go back. Oh, Ms. Willis, okay.
Madam Chair, I'm just wondering whether we should be a little more generic. I mean, a blanket easement, depending on Mr. Lalonde's plans, he may end up registering, I don't know, the block beside it before the expiry of the conditions, and it may be easier for him to change it from a blanket easement into a specific easement because he's going to have road allowances anyway. Just not, I mean, maybe that's out of beyond the realm of possibility, but I don't know whether saying a blanket easement ties it down in any way, and maybe we just keep it even more generic where it's an easement to provide access to the property from a public street to the satisfaction of somebody or other. Because blanket, once he registers his plan, it becomes complicated, and it may be that maybe Mr. Lalonde could even comment on what the expected timing of registration of that plan is.
I just want to, before we go to Mr. Lalonde, I just want to be clear. So this committee in approving consents and easements, either we go with a sort of a more generic approach to it, or if we're saying, because I personally am not comfortable to say, go away, Mr. Applicant, and it's approved, but go and put a 4R plan that satisfies. I myself, as a committee member, and I was making this decision, I would want to see that on a 4R plan. I would want to know what easement I'm granting and what it looks like. I think it's part of the decision on this application. So either we go with a blanket in my mind, or we're pausing. We're giving time to Mr. Lalonde to go out and get a 4R plan and come back.
So if I can speak to that, Madam Chair, and to answer Member Willis through you, Madam Chair, I think the blanket easement can work, and I think with any future subdivision registration, we can discharge that easement and recharge it as necessary. Our registration process can create public road access to some of these lands, and we may need to simply redefine what the blanket easement needs to be at that point in time. So if there's a registration on part of the lands, we just discharge and reapply for an easement at that time. So I'm quite comfortable moving ahead the way that it's been suggested as a condition, letting Mr. Hodgins go away and work at it with legal staff and coming back to members of the committee as well as myself if that's possible. And I'm quite confident that there's a positive outcome here.
Okay. All right. Thank you, Mr. Lalonde. Mr. White.
Madam Chair, can I suggest as well that the city, in reviewing the subdivision application for the lands to the east, that they take into consideration the requirements for the access issues that we've identified. In other words, in that subdivision agreement, that they consider provisions that will facilitate and ensure that access is available.
I think the best we can do in that regard, Mr. White, is to say to Mr. Hodgins to be sure that he shares that information with his colleagues.
That's all I'm saying. Yep.
Okay. All right. Okay. I'm going to get back to the decision now. Let's see if we can wrap this one up. So all of those in favor of the consent application, please, subject to a mutually agreeable blanket easement condition added. All right. Okay. I've got to tell you, I'm really on the fence on this one because I still don't think I've heard the planning evidence I need to demonstrate to me that this is still the better way. But there's been a lot of good faith moving forward. So I am going to join my colleagues in supporting the consent application. On the minor variance, all those in favor? All right. Okay. So I think that is pretty unanimous. Okay. Looking at, there's no conditions at this point. There's other than the condition that we're adding. So I think we have an approval. I think that's it. Anybody, as far as I'm concerned, we're good with this application. Okay. Well, thank you very much. We really appreciate your input and you're providing us with the background that we need and your presentation, Mr. Anais. So thanks and good luck. It looks like you've got a lot of work ahead of you for years.
Thank you.
All right. Thanks so much.
Thank you, Madam Chair and members.
All right. Thank you. Okay. We're going to go to application number 3. Which, or sorry, not, yeah, it is, I guess. It's item number 3 on the agenda, which is 2128 Trim Road. And I am looking for Mr. Tran and Mr. Winters. Good evening.
Good evening, Madam Chair and members of the committee. How are you?
Hi. So, all right. So, Mr. Garfinkel, you are the agent. Okay. I see. Okay. So I've got 3 agents. That's why it's a bit confusing.
Yeah. So I represent the owner and developer, and then I also have Robert Tran and Greg Winters from Novatech, who are our consultants.
Okay. All right. So before we get underway, Mr. Garfinkel, I'm going to aim this at you unless you tell me otherwise.
Nope, it's fine.
Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted on the property to which the application applies for the prescribed number of days prior to the hearing, that it was clearly legible and visible during the entirety of that time? And do you swear or affirm that to be true?
I affirm that to be true.
All right, thank you. We are looking for a brief presentation from either you or one of your friends. Mr. Garfinkel.
Yeah, so I'm just going to introduce quickly the request for the variance in the site, and then I'll hand it over to Robert from Novatech. So we are here today to request a variance on our multi-res site in our Provence-Orleans subdivision to permit parking in the front yard of our planned unit development. So the site is located within phase 2 of the Provence-Orleans subdivision. We refer to it as Block 126 or the City Towns at Provence. The site's located at the southwest corner of the Millennium Drive and Trim Road roundabout, and it will be accessed from the future Ventoux Avenue. The proposed development includes plans for 40 back-to-back townhome units on private streets. It has associated parking, landscaping, and snow storage. There is a concurrent site plan application that is running with this, and we are fairly close to ironing out all of staff's comments. The subdivision was zoned in 2019, and the block was always intended and designed for what's currently shown on the site plan, which you see on your screen now. The variance request is really due to a technicality in the zoning, and it really is desirable due to the functionality of the site. Regional has done a lot of these private site developments, and we found that providing visitor parking and snow storage are absolutely crucial for the functionality of these sites. The visitor parking spots operate in this site operate very similar to window streets that can be seen throughout the city of Ottawa. And we have also, staff's major concern was just that we provided sufficient screening via a landscape buffer. And we have shown that if you actually flip to the next slide there. And staff are now satisfied with the landscape buffer that we are showing. I'm going to pass it along to Robert now to just speak a little bit further.
Thank you for that, Evan. Good evening, Madam Chair and members of the committee. My name is Robert Tran, and I am the agent from Novatech representing the applicant for this minor variance application. So as Evan previously mentioned, the subject site is situated in Ward 19, Cumberland, in the Notting Hill neighborhood of Orleans at the corner of Trim Road and the future Ventoux Avenue. The subject site is an irregular shaped block of land within the future plan of subdivision known as Provence Orleans and has an area of approximately 0.98 hectares. The applicant, as Evan previously mentioned, is proposing to develop 40 back-to-back townhouse dwellings, as well as provide some surplus parking as part of the development. Can you please go back to slide 1, the site plan? Thank you. So the minor variance application is to permit 7 parallel parking spaces within the provided and required front yard, as shown in red on the site plan. Section 109, subsection 3AI of the City of Ottawa zoning bylaw prohibits parking spaces within a provided and required front yard. Due to the proposed development's classification as a planned unit development, the subject site is treated as one lot for the purposes of zoning. And so the part that fronts onto the feature Vaughan Avenue is treated as a front yard because of the proposed 1-foot reserve along Trim Road. The minor variance would facilitate additional parking spaces and seen as an overall benefit to the development. The location of the parallel parking spaces is an efficient use of the land while ensuring that parking is contained within the subject site and does not spill over onto future local streets. So please go to the next slide, the landscape plan. So as shown in green on the landscape plan, appropriate landscaping screening measures will be provided through a variety of tree and shrub plantings adjacent to the proposed parallel parking spaces. Examples of the plantings are provided in the next slide. Please go to slide 4. So as shown in the image here, this will ensure that a visual separation and buffer is provided of the parallel parking spaces from the streetscape and public right-of-way once the subdivision is fully built out. Further, it should be noted that the layout of the proposed parallel parking spaces within the subject site functions similar to window streets, as Evan mentioned, where on-street parking is provided and found in new residential subdivisions in the City of Ottawa, as shown in the next 2 slides. So please go to slide 5. And now slide 6. So the examples demonstrate how the parallel parking spaces would function similarly to what we call window street designs, where parking is permitted. And so given the irregular shape and constraints of the subject site, parallel parking spaces were identified as the most efficient when compared to traditional or angled parking spaces. And as such, the layout is both compatible and consistent with street designs for new residential development in the city. And in regards to the 4 tests of the Planning Act, I'll just go through them briefly. So the first test for minor variance is that the general intent and purpose of the official plan is maintained. The subject site is designated as general urban area in the official plan. The purpose of this designation is to permit a development of a full range and choice of housing types to meet the needs of all income, ages, and life circumstances. So the parallel parking spaces maintains the intent of the OP as they are providing parking as part of this residential development, and no changes are proposed to the subject site that would deviate from the intent and purpose of the general urban area policies. And as such, the minor variance maintains the general intent of the OP. So the second test for minor variance is that the general intent and purpose of the zoning bylaw is maintained. The subject site is currently zoned residential third density subzone YY, urban exception 2328 under the City of Ottawa zoning bylaw. The purpose of this residential third density zone is to allow for a mix of residential building forms in areas designated as general urban area in the official plan, to allow for a number of other residential uses to provide for additional housing choices, to regulate development in a manner that is compatible with the existing land use patterns so that the residential character of the neighbors is maintained or enhanced, as well as to permit different development standard, primarily for development communities which promote efficient land use and compact form while showcasing new design approaches. So the requested minor variance will enable surplus parking as previously mentioned and does not result in a change in the residential land use. Given the proposed development's classification as a planned unit development as previously discussed, the part of the lot with frontage onto the Vaughan 2 Avenue is treated as a front yard. The requested variance to permit parking within the required and provided front yard does not result in the front yard parking prohibitions as intended by Section 109 of the City of Ottawa's bylaw. So please go to the next slide. So as shown in this image here, the variance does not result in the front yard parking prohibitions as intended by the bylaw. The parking spaces are essentially considered as on-street parking and are appropriately set back from the townhouse dwellings by the 6.7 private street. As such, the minor variance maintains the general intent of the zoning bylaw. The third test for minor variance is that the minor variance is considered desirable for the use of land. The parallel parking spaces would enable additional parking spaces for the development are not required under the City of Ottawa zoning bylaw. These additional spaces are seen as a benefit to the overall development and is an efficient use of the land while ensuring that parking is contained within the subject site. As such, the minor variance is considered desirable for the use of land. The last test for minor variance is the variance from the provisions of the bylaw minor. As previously mentioned and shown in the images, the layout of the parallel parking spaces functions similar to window streets where on-street parking is provided and already found in new residential subdivisions as shown on the images. Appropriate landscape screening measures will be provided to ensure that a visual separation is provided of the parallel parking spaces, and those were shown in the images provided before. And given the developing nature of the community, no current or existing residential dwellings will be impacted by the proposed minor variance. And as such, the minor variance is considered minor in nature. It is our professional opinion that this minor variance application meets the 4 tests as required under the Planning Act. Thank you.
All right, thank you very much, Mr. Tran. All right. I'm going to open it up to questions for the committee. Mr. White.
Thank you, Madam Chair. I'd just like to ask, am I correct in saying, looking at the site plan, that these units include driveways and garages?
That is correct.
My second question is, what are the bylaw parking requirements for the development, and what is provided? It did indicate that these are in excess of the requirement, but I'm wondering what the bylaw requirements are and what number of parking spaces are provided on the site plan. I'm just trying to get at, are you meeting the parking requirement without the, I believe you, I'm
Yes.
sure you are, but I want to know if you're in excess of the parking provided requirement that is actually provided in the site plan with the garages and driveways and that sort of thing.
We are in excess. These 7 spaces up top are in excess of the parking requirement. So we are meeting the requirement of the bylaw without them.
Okay, what are the numbers? What's required and what's provided on the site?
Robert, can I pass that along to you, please?
Yes, through you, Madam Chair. There is a provision in the City of Ottawa zoning bylaw, section 102, subsection 4. So given the proposed development, which includes driveways as well as garages, the parking spaces are provided within these measures. So, you know, it's parking will be provided in the garage and as well as on the driveways. So there is no minimum required visitor parking for this type of development, which...
Mr. Tran, that's not Mr. White's question.
Oh, that's not a question.
Mr. White is saying, okay, based on the development that's proposed and the standards in the zoning bylaw,
Right.
how many parking spaces do you actually need? And then so that's, I guess, what we're trying to get at. How many are, and so you're asking for 7 additional over what's on your site plan. We understand that, but we don't even know at this point whether or not there's more shown on the site plan that's actually required. So I guess that's the question we're asking. So what are the numbers?
So the numbers for this, so 1 parking space is provided for each residential dwelling. And then it would be 0.2 for each dwelling unit, which equates to 8 total parking spaces for the overall development.
Sorry, 8?
Yes,
How many?
there'd be 8, but there is a provision within the bylaw that does not require any visitor parking based on the plan unit development proposed.
Sorry, Madam Chair, if I could
So,
introduce.
Mr. Winters, actually, I'd like, Mr. White was about to,
Madam
I'd
Chair,
like to.
I'm not looking for the visitor parking. I'm looking for the total parking requirement based on the number of units versus, and the number that are actually provided on the site.
Do you have a part, sometimes on these plans, these site plans, there's a requirement to actually show what the parking requirements are from a bylaw standpoint versus what's being proposed. And they're often broken down between by dwelling unit and by visitor parking space. So do you have that? Mr. Winters?
Madam Chair, so the rate in into the suburban neighborhoods is 1.4 in total. So you're required to have 1.2 spaces per unit plus the 0.2 visitor spaces. So that would a total up to 56 spaces required in total. But each one of these units, 40 units being, actually provides 2 parking spaces. There would be one in the garage and one in the driveway. So you'd have 80 units, 80 parking spaces. But what we typically find on these developments is that, you know, all you need is 1 or 2 people to have a house party or something in pre-COVID conditions. And then what ends up happening is you end up having people park either on Vaughan and having to walk in, or they have to park on one of the adjacent streets. So what Regional and EQ have found that's been quite successful in their developments is to oversupply just a little bit of additional visitor parking in and around the development to allow that situation to occur without starting to impact the future residents that are going to live on adjacent streets.
All right, so Mr. White, do you have then, like I didn't write down the numbers. Did you do the math? What are we talking about in excess of the required? Okay, so sorry, Mr. Winters again. So it's 1.2 per unit. So you've got 40 units.
Plus 0.2 visitor spaces.
So, and that brings us to a total of what required then?
56, Madam Chair.
56, thank you. And what we're actually providing is 87.
That's correct.
All right, so.
That includes, sorry, Madam Chair, that includes your garage and your driveways? Okay, thank you.
I did notice, Mr. Winters, that there's also a few parking spaces sort of tucked into the corner of the site plan. Is that above, again, above the 2 spaces per unit plus the 7 plus that?
That's correct.
That is, but that area is also intended for snow storage, so you end up losing those spaces in the winter.
I know, but it's on the site plan, it says parking, it's a parking space, so I need to address it in that way. So again, back to you, Mr. Winters. So the 87 includes those spots or no?
That's my understanding. No, it does not, Evan. Sorry. I thought they.
All right, let's get some clarity on the parking. This is like a mathematical thing. I'm beginning to wonder how come we can't get our numbers right. So you've got 40 units, you got 1.2. I'm going to get my calculator out. So is that the 56 then is the 1.2 times 40 plus the 40 times 0.2, add that together, now you have 56?
Yes.
Okay, so the added parking spots that I see in the corner that you say are for stores, that's how many? How many have we got there?
It's 5, Madam Chair.
That's 5, Madam Chair.
5? So you've got so you've actually got 60, let's see, wait a minute. Yeah, so that's after the 87, so it's 87 plus those 5?
What I get in total, Madam Chair, is 92 spaces, because I was saying that you have 1 in the driveway for each unit, 1 in the garage for each unit. That's 80 in total. And then you have the 7 that we're requesting out on to Vaughan 2. And then you have the 5 in the corner. So when I add those together, I get 92.
Thank you. That's exactly, I guess, what I was trying to get at this point.
And okay. Madam Chair.
That's fine. And so 92 and the requirements is 56. Okay. Mr. White, do you have any other questions with regards to the parking?
No, ma'am. No, Madam Chair. I think I'm good with that.
All right. Anyone else from the committee have any questions? Yes, Ms. Markovich.
Yeah, just sort of you mentioned this concept of window street throughout your application. Is it anything more than just a street with on-street parking? I just want to make sure I understand what that you reference it quite heavily. Is there some sort of official definition there that is beyond that, or can you expand on that?
No, I think what we're referring to is that it functions similarly to a window street, and it's just a private road. It's a 6.7 meter wide private road. There's nothing more to it. It was just mentioned to refer to how it functions.
Okay, and so a window street, when you say that, what sort of, I'm not 100% clear on that definition.
So if you can actually pull up the slides, it's probably easier to take a look. But it's essentially two streets that are running parallel to each other.
Okay, right. Thank you.
So I don't know if that answers your question, but I see the screen coming up here. But you can see these two streets, Yellowcrest and Rochefort, along Brian Colbert, just run parallel to each other, and then they're buffered by a landscape.
Okay, and those examples that you've provided, so like figures 5 and 6, they're recent developments. Do you know how recent those are, those examples you've submitted?
Not off the top of my head. These aren't our developments, but I would assume probably in the last 5-10 years.
Okay, thank you.
I'd like to speak with Ms. Ramirez about this. So if we can bring the screens back then. Ms. Ramirez, I would like to echo some of the comments, I guess, that we heard from Ms. Markovich. There was a lot of reference to these window streets. And as you know, the committee really does try to keep on top of the latest, what's going on in terms of design for the and this one was a bit of a new one on us. So we were trying to understand what, whether what's the definition of a window street? What's the criteria for the use of a window street? And is the city actually moving in that direction sort of in a more general way? So I guess we're just trying to understand that. Let's start with that. If you can just give us a little background, please.
Through you, Madam Chair, I'm not very familiar with the term. I looked at it from this application from the perspective of was the parking going to be screened from the streetscape with landscaping? And they are providing a landscape buffer that will help mitigate some of that visual impact. And looking at, so that was sort of one of the things that I focused on in terms of this application. I didn't focus on the window street, I guess, rationale.
It's not, this isn't a trend that we're missing here that somehow is that we need to know a bit more about. Mr. Hindle, go ahead. Oh,
yeah, Madam Chair, I can speak from my previous experience in land development that, yeah, window streets are quite common these days. Rather than having homes back onto major streets, which creates a bit of a wall in the community. So the design trend right now is to do window streets so that you get local access without losing the efficiencies of effectively having a highway of a major street. So you get the openness of allowing people to walk through, but you get the efficiencies of that collector and minor collector kind of system.
I've certainly seen them in Toronto, that's for sure. I've not seen examples so much in Ottawa yet, but certainly seen them in Toronto used a lot. Mr. White.
Yeah, Madam Chair, that's where they came from. Actually, I recall working with people at Minto in particular about probably 15 now, maybe going on 20 years ago, where they first brought them to Ottawa, and they were using models that were being done in the Toronto area, particularly the Toronto suburbs like Milton and some of those others. Mattamy brought them as well from the Toronto area. There, if you go into most of the new subdivisions, you'll see them all over the street, place where the units front out onto the street, and you have that the essentially double street situation that we're looking at right here. So it's not new. It was brought to Ottawa by, and I would say Minto. I think my experience was mainly with them in the early days of Chapman Mills and those types of those subdivisions in Barrhaven. So it's not new.
Fair enough. I guess I was just, so I know they're used, and I guess part of what I was trying to get at is there sort of criteria that's used by the city to determine when and when not one of these window streets should be implemented? Mr. Winters.
Yeah, Madam Chair, what we typically find is it happens in areas like this along more collector roads and stuff where the development, the city staff really are adamant that they want to see a front door facing onto a major public road or a collector road. But the problem we tend to run into on that is you end up with traffic conflicts or whatever. Whereas the developments typically want to be interior facing. So in older school planning, and I'm old enough to remember doing this, we used to be able to orient the buildings so that the backyards faced out onto the street. And then we'd be forced with a noise barrier along that roadway. And the city policy right now is very adamant that they don't want to have any noise barriers. They fight them, and they're only used in a last case situation. So in these situations, just to Mr. White's position here, is that they started introducing these window streets as a viable option to be able to provide front doors without creating the conflicts onto the collector roadways. And they work quite well in this situation on these newer type products that we're starting to see now, where we have these back-to-back units on these private enclaves. It allows for that little separation of traffic for people to come in. You avoid noise barriers, but you still have some sort of a physical presence. So as people are walking down Vaughan in the future and along Trim Road, to be able to look across that landscaping and be able to see the front doors of units.
You know, then, Mr. Winters, do they actively like sort of look to some of these streets to provide parallel on-street parking, to provide added capacity? Like, is there another sort of parking objective that is met through the use of those window streets?
Not really, Madam Chair. It's really just a function of that you need to provide some sort of an access to the front door of the units without impeding some of the more collector road functions of the roadway. You have to envision that in the future, this is going to be a fairly busy intersection because it's got a roundabout directly onto Trim Road. So you can only imagine if you were a future homeowner and you were trying to back your car out at that intersection in the future. This provides that nice reprieve from that situation.
No, certainly from that standpoint, I can see it. So I have one last question, and that is, can you tell me where transit is? So how close to transit? I would imagine you're right next door to a major corridor, right? For transit?
Yeah, Madam Chair, at the south of the site, there is a block that we are dedicating throughout the subdivision to the city for the future transitway that's identified in the city's affordable plans beyond 2030. Forget what the year is, 2036, affordable transit network. So we are quite close to transit, and then we are right against Trim Road as well.
All right, thank you. Okay, good. That's good comprehensive information to have. All right, anyone with any further questions? I think we've talked about a lot of stuff so far. All right, I'm going to open it up then to the public hearing portion. I don't have, again, anyone on my speakers list. It's been a quiet night from a speakers list standpoint. But that said, always an opportunity for anyone who is still with us at 9:22. Anyone who would like to speak either for or against this application? Okay, I'm not seeing any hands raised at all at this point. So, committee members, I'd like to know all those in favor of the application. All right, so Mr. White, I see that your hand was not up.
Madam Chair, I just have difficulty with the parking numbers. The numbers that we're seeing, I mean, the city's always, as far as I am aware, at least recently been promoting the removal of front yard parking and parking numbers to begin with. A lot of units, as you know, unit types in the city are permitted to develop with no parking requirements. And I think in the situation here where we have some, I think I heard 90 some spaces provided on the site in excess of the 56 that are required. My preference would be to see a window street that's fully landscaped or provided with all the landscaping potential that it has. And I'm not seeing parking numbers here that I feel are onerous to the developer that a 7 parking space loss is going to hurt the development significantly. So I'm not supporting the application.
All right, thank you, Mr. White. So in that case then, gentlemen, I think what you're going to get is I still saw 3 people on the committee in favor of the application. So the application does succeed, it's granted, but I'm going to join Mr. White in dissenting against the application for exactly those reasons. I think that that in fact the test here is it minor? I don't think is it minor? I'm trying to figure. No, I guess I'd have to rely on it's not in keeping with the spirit of the official plan. If I had to pick a test that I think probably it wouldn't fit, it's the official plan, which really looks at trying to minimize, minimize parking and, in favor of, especially with transit right nearby. That was sort of the point of my question is, we do have other options. There's, like Mr. White mentioned, there's almost a doubling of the required parking on site already. So for that reason, I'm going to join Mr. White on the dissent, but your application is granted all the same. And I guess you'll get to move ahead with your site plan development. So good luck to you, and thank you for your responses this evening. It was good to have fulsome information, like I mentioned. Thank you.
Thank you, Madam Chair, and members of the committee.
Thank you. Okay, I think the next one that we're looking at is applications 11 and 12 for 21 Cedar Road. And I believe I've got Mr. Simpson as the agent. Yeah, Mr. Simpson. All right, Mr. Simpson, I see you're there. Ah, perfect.
Okay, sorry.
All right, so Mr. Simpson, before we move forward, I've got to read something to you and get a response. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted on the property to which the application applies for the prescribed number of days prior to the hearing, and that it was clearly visible and legible during the entirety of that time? Do you either swear or affirm that to be true?
I do swear.
Okay, so I think we're looking for, at this hour, a brief presentation from you, Mr. Simpson.
All right, can you hear? Basically, on behalf of the owners of 21 Cedar Road, I just want to make sure you can hear me.
Yes, we can.
Okay, thank you. We're seeking the committee's permission to sever 21 Cedar Road, which is a vacant residential lot of 5,410.9 square meters or 58,242 square feet, into 2 lots, which will be 28,790.47 square feet and 29,452.46 square feet. I'll use square feet unless you want me to use meters. Now, the proposed severances requested to divide this large lot and then into the 2 separate residential developments is in keeping with the residential zoning of the area and the official plan that supports single-family homes on lots with a minimum area of 14,961.96 square feet or 1,390 square meters. The properties, when severed, Part 1 will be 92.42% larger than the minimum lot size, and the Part 2 will be 96.85% larger than the minimum lot size that is being requested under the bylaw. However, 21 Cedar Road has a narrow frontage that broadens as it goes back, as many lots in that area do. Our severed lot, Part 1, will have a frontage of 25.26 meters or 82.8 feet. And the minimum lot size that we'll be seeking minor variance on is 30 meters or 98.43 feet. That is a deficiency of 15.8%, deficiency in the front lot. And on part 2, our deficiency is 16%. We'll have 82.7 feet of frontage. Now, with that said, our lot size at the back of the property as it broadens is 123 feet or 25% more than the minimum lot in the front. So we make up in the back, and and as I pointed out, our lot size is double, almost double what the committee is or the city is looking for a minimum lot size. Now, in our form, our application, we show with a site plan, we can accommodate a 3,250 square foot new house floor plate. The Patterson Group engineers designed a conceptual sewage system that meets the OBC 2012. It conforms with it. So the 2 lots will have sufficient size for the proper septics, and we will have access to the City of Ottawa water service. The severance into the 2 lots would make the large property, more manageable and efficient for two residential homes, and the smaller lot sizes would make them more affordable for their future owners. With the construction of the 2 houses, obviously the City of Ottawa will have the benefit of realty taxes we project within 2 years. And therefore, we ask the committee to approve this minor variance, the severance of the lot, but with the minor variance for the frontage, which we feel double the lot size required, and the broaden 123 feet in the back rear lot more than amply makes up for the front. Now, if you don't mind, Madam Chair, there were the few comments from the neighbors and the association. Yes, I can't hear you.
I rarely mute myself, so then I could totally forget. That's why. So, Mr. Simpson, I guess I was looking at your report, and I wondered, did you address the 4 tests under the Planning Act?
Yes,
for this?
yes, and if you read the Planning Committee, they approve. They have no objection. We met our 4 tests. And
because it's not in the submission that I have
yes,
from you.
Well, unlike some of the other presenters, I write that if you have to, I didn't say number 1, the minor only because, I didn't say desirable amendment because in my presentation, we meet the zoning standards, the residential lot size, we doubled the lot size. The only thing we don't have is the frontage. We are 15.8, 16% short, but 25% larger in the back. We feel that is more than makes up.
I understand. I mean, we did see the numbers. You talked a lot about the numbers, but you know what the plan. When you come to the Committee of Adjustment and you are arguing evidence, then the expectation, and this is just going forward, is that you in fact use the 4 tests of the Planning
I did.
Act.
Okay, I'll break it out if you wish.
I'll be honest with you, it wasn't. I didn't see that. So I'm just suggesting that maybe you maybe structure it like that the next time, perhaps.
You're used to people writing 1, 2, 3, 4. I answered all the questions, and the planning department saw that I did answer all the questions.
I'm just suggesting that you look at doing that in the future.
Fair enough.
Okay, that said, any questions from the members of the committee on these applications? All right, I do. I have one, Mr. Simpson. You started to go in that direction, and before you go there, can you tell me what kind of consultation you undertook prior to submitting your applications?
We did not do. We talked to the planning department. We went down and saw the zoning. We talked with the planning department. We did a preliminary site plan to show the planning department wanted to make sure that we had enough land for the septic system, and we met all the setbacks. And we showed them in the preliminary plan that we do meet them.
Mr. Simpson, going back to my opening words, you wanted to address some of the comments from.
Yes.
So that's the consultation I was asking you about.
Well,
public consultation, neighbor consultation. How
But
much
the
did you
comments, with all due respect, the comments, well, there were two comments. 50, the neighbor behind at 53 Rothwell, he was concerned that the new houses would be built within the 80 to 90 feet off the back rear lot line. And that is something that is always occurs in the building permit process, and it would be met. But it's nothing to do, it wouldn't have any impact on your committee, because the building permit would require any houses to be within the setback area. So I answered that by saying the application process will take care of that. The Rothwell Heights Property Owners Association, their concern was we might lose trees and green space. There used to be a house on that property, an old house. It was torn down because it was full of mold and that. Two new properties, when they go for building permit, will have all the landscaping required from the city. There are some lovely trees on the property that the city has rules. It would be incorporated into any building permit landscaping plan. The association basically was putting the cart before the horse, because that is a process that not with the committee of adjustment, but with the building permit stage, where it would all be talked about, and they're concerned, by the way, on they were concerned that be a lot of hardscape. We'd lose landscaping. Again, that is up to the building permit stage. Most people wanting to buy and live in that Rothwell Heights area appreciate, they're buying there to appreciate the growth, the trees, the heritage look. So I think their concern is not, it's a concern for the planning department when we go for building permits, not at this stage. We are asking for a severance of one lot that is more than sufficient, and it's just a minor variance in the front lot that we feel is accurately corrected by having a larger back lot and double the lot size.
Do you have any questions for Mr. Simpson? Mr. Hindle.
Yeah, I note in your letter that these properties will be serviced through septic. Is that correct?
Yes, there's no sewer in the Rothwell Heights area, in that area.
Okay, but you noted that you're confident in this case that lots meet the requirements for that and can be successfully designed for septic?
Well, we hired Patterson Engineering to do a preliminary concept, which we attached to our application, and they have no problem. We have enough space, and they so state in their letter.
Perfect.
Yes, we're double the normal lot size. So if there was an issue for 15,000 square feet, when we're almost 30,000, we have no issue with that. But the Patterson Group It was advised that we should hire we should get a report when we went to planning, which we did. So you'll see Patterson Group have stated that they are that those two lots are fine.
Okay. No, thank you.
Okay, I'm just looking at the conditions here. There's a number of conditions, Mr. Simpson. Have you had a chance to look at them all?
Yes, they're all issues that are dealt with at the building permit stage. Every one of them would be dealt with when the architects and engineers go to the city for consultation and building permit.
You do realize that all of these conditions have to be cleared within 12 months.
Yes.
Okay. All right.
Now, okay, yes. As I stated in my presentation, we anticipate the two houses being built within 2 years. You're just putting a greater timeline on it.
No, the Planning Act puts a greater timeline on it,
All
Mr.
right.
Simpson, not
right.
me, just to be clear.
But again,
Mr. White?
all those 7.
Yes, Madam Chair, I was just going to point out that these conditions have to be met before the certificate of consent can be issued. So the lot cannot be created until all of those conditions have been satisfied by the city.
Yeah, and I'm looking at that. I'm looking at some of these things here, and there's quite a bit, to be honest with you, to cover. But that's fine if Mr. Simpson thinks that he can clear these conditions within 12 months.
There's no problem meeting those conditions.
Okay, sounds good. So you have no concerns with any of them? I think that's what I'm hearing, okay?
No.
All right, so before we move on this, I don't have any, even though there is some opposition, I did not see anyone on the speakers list for this item, but I need to make a call out to anyone who might be part of the audience still and has an interest in this application. If you would like to speak either for or against, you can do that at this point. Not seeing anybody really too much left at this point, but okay. All right, so we're gonna close that public hearing down. I just have one question for you, Ms. Ramirez. In terms of the trees, because we have had, all right, okay, so we need a tree agreement, and that is in accordance with the new tree conservation bylaw that came in effect as of January 1st. That's correct?
Through you, Madam Chair, we do need a tree information report, and we're sort of in the between stages on applications that are now deemed complete after January 1st. We'll have to have that at the time of coming to Committee of Adjustment. There are a number of trees on this property, and our forestry staff asked for that we make it a condition of the severance to have that tree information report, and that there's quite a few things that have to fit within this lot, and that tree protection is going to be one of the things that we're looking for, and that's why we're asking to enter into development agreement requiring that the tree protection mitigation measures be implemented, and that we can have some say over where things go to protect the trees.
All right, okay, thank you. That gives us some comfort, because as you know, there's been some concerns in the Rothwell Heights community about that. So I just wanted to make sure that it had been covered off, knowing that that's an issue for the, or of concern to, rightly so, of the residents. So that's fine. All right, so I need a decision at this point, everyone. All in. Oh, wait, Ms. Willis. Yes.
I have just a couple of questions for staff on the conditions, notwithstanding Mr. Simpson's confidence that he's going to have these houses built within a very short time frame. And that's conditions 4 and 6. And I'm wondering whether condition 4, which requires the approval of the Ottawa Septic System Office, does the plan that it's not wrapped into condition 5, which has a whole bunch of other things that are required that will be secured by means of a development agreement. So is this a requirement? Let's say the house is not built for a few years. is it not premature to require the detailed design and the approval of the septic office before the house is finally designed, particularly when you've got condition 5 that already requires all the, I guess what I'm saying is, can condition 4 be wrapped into the development agreement that's required as part of condition 5? Was my first question. And the second question was just about the asphalt overlay. It was my understanding that if you have more than 3 road cuts or more than an asphalt overlay is required. And is that different in this case because of the width of the lots, perhaps?
Through you, Madam Chair, to answer the question regarding the permit from the Ottawa Septic Systems Office, what the office has done has in the past have been provide us with a letter saying that when the applicant comes to get their permits, they will be issued it. And so we use that letter as a sign off. With respect to the septic system impact assessment, that is the city is requiring or asking for that to make sure that the aquifer is not negatively impacted and that people who rely on groundwater, that their water is protected.
Okay. And the overlay?
Oh, the overlay. Yes, thank you. An asphalt overlay is required if there are 3 cuts within, I believe it's 12 meters. And so when we get the grading and drainage plan, it shows where the cuts are. And so if they're within 12 meters, that's where of each other, that's where we would require that asphalt overlay.
But in this instance, you're requiring one in any case?
Through an abundance of caution, we include this condition when we see that grading and drainage plan, because it takes into account the cuts for the existing services, but also the future. So when it comes to we can determine at the grading and drainage plan if we require this at that moment. And so we ask for it now so that if we do require it, we can have it. If we do not require it, then our engineering services staff send a note to Committee of Adjustment saying that it's not required and that they can.
So it's not automatic that even if there's only one cut, that they're not going to require it because he's agreed to it. I was just wondering, maybe it should say if required, because I think we've done that before.
I will make a note of that.
Just on that then, though, I think Ms. Ramirez, if I understood you correctly, though, it's not just any road cuts for the purposes of this particular development. It would be any road cuts in the future. Are you meaning in tied to this project or could be some other project? Like, I'm trying to understand what you meant by in the future.
Yeah, so what I meant by in the future is that when they put the laterals in for the servicing for the proposed dwellings, and then so when they cut off the existing services, that's when they have to cap and blank the services, but also when they put in the new laterals for the new buildings.
So it could be that they could put, I mean, it may end up being 3 anyway, because they may have to blank the existing one. So it may end up being 3, but it may be that they only need 2 in any case. And what you're saying is if there was only 2 required, then the asphalt overlay will not be required. Is that okay?
The new water.
Got it.
Thompson, I saw you had your hand up. Did you want to say something?
Just to answer that. Because there was a house previously, there's already a road cut. And all we'd be doing for the next lot is adding one more road cut. Then they certainly would be probably the distance apart that was just mentioned. But you're going to have 2 houses, 2 entrances, a typical, it's a typical layout for a house in that area. It wouldn't be a problem. We can meet all those guidelines, which are the guidelines that are met for building permits. We'll meet them now, and we'll just get the work done sooner.
All right, thank you. I think it's time for a vote on this application. All those in favor of the application for consent? All right. For the record, the application for consent is granted unanimously, subject to all of the conditions that were identified as part of that approval. So with that, thank you very much, Mr. Simpson, and good luck with the project.
Thank you. Thank you, Mr. Chair.
All right. I believe that takes us to the last application of the evening, which is application 16 for 799 Melfa Street. So I think we started with the discussion and we're back around. So excellent. Okay. We are going to need either Mr. Poulton or Mr. Chown a brief presentation, and I mean brief presentation on this, if you will, please.
For sure, but I also have to swear the stat deck.
Ah, thank you. Ha! It's pretty bad when it's somebody else reminding me at this point. Okay, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted on the property to which the application applies for the prescribed number of days prior to the hearing, that it was clearly visible and legible at all times? Do you either swear or affirm that to be true?
Yes, I swear.
Thank you very much. Okay, and thank you for the reminder. Okay, over to you then on a presentation.
Okay, so I'm acting as agent on behalf of the owners and have filed the reciprocal consent applications to create a new lot north of the existing dwelling at 799 Melfa Crescent. 799 Melfa Crescent is a pie-shaped lot on the west side of Melfa Crescent. The property is west of Mooney's Bay and the Rideau River and east of Prince of Wales Drive, and it's south of Hogsback. There's on slide 2, it's a zoomed in image of the property. If we can go to slide 2. Go. So there's an existing dwelling on the property today. It has a detached garage and a carport and a driveway providing access. There are residential properties both north and south of this property. I would like to note on this figure, the lot lines, this is from on the previous image, the lot lines, that's from Geo Ottawa, and they're not representative of where the actual lot lines are on the property. Those are shown on our draft reference plan we've provided. That's the next slide. Thank you. So these are our consent sketches. It's using the draft reference plan as a base map. For consent application 1, it includes a new proposed vacant lot. It's part 1 on the draft reference plan, and it will have a lot width of 22.07 meters and a lot area of 813.2 square meters. Consent application 2, which is the next figure, is parts 2 and 3 on the draft reference plan. And it's going to have a lot width of 32.51 meters and a lot area of 1,256.9 square meters. These are straightforward reciprocal consent applications, and all it does is create one new lot that's currently vacant. The property is within the general urban area. It's designated general urban area. The official plan supports intensification and infill development in and specifically on lands designated general urban area. The property is within the residential first density zone, subzone GG. The proposed lots meet the lot width and lot area performance standards of the R1 GG zone. So what we're proposing here is fully conforming lots in terms of the zoning bylaw and the intent of the general urban area. On slide 5, I think it's just a blow up of the draft reference plan, but it's a little bit more clear. You can see the pie-shaped lot, parts 1, 2, and 3. You can see the existing encroachment issue along the existing lot line to the north. As well, on the proposed lot line, you can see the detached garage that's existing on the property today, as well as barely, but just the part of the carport that's existing today, cross the proposed lot line. So with regard to the at 799 Melfa Crescent, that detached garage and the carport will be demolished. And therefore the existing house will meet the interior side yard setback from the proposed lot line. So there'll be no structure crossing the proposed lot line. in terms of the carport and driveway at 789 Melville Crescent, that's the property to the north, you can see the existing encroachment conditions. That is an existing condition. It's not proposed to be changed at all. We have a letter from the neighbor acknowledging this is an existing condition, and both that owner at 789 Melville Crescent as well as the owner of 799 Melville Crescent are okay with the existing condition continuing. And should 789 Melville Crescent develop in the future, they'll be required to rectify that situation. On slide 6, you can see the existing home. These are just some street view photos quickly. Blurry street view photos, apparently. Oh, okay. So sorry, the first one on slide 6. Oh yeah, okay. So you've just gone through the 3 slides, but yeah, slide 6 shows the existing house with the carport and detached garage. Slide 7 shows the new lot that's being proposed that's currently vacant. And then slide 8 shows the house at 789 Melville Crescent. I'll have to try to make sure these aren't blurry in the future. It shows the existing carport structure as well as the driveway, including interlock brick. I would note that existing carport structure is just basically 2x4s on posts with fiberglass panels roofed, and that is all that encroaches onto the proposed severed lot that's vacant. So we are aware of the comments in the staff report regarding the existing encroachment. So yeah, we do have that letter from the neighbor acknowledging the situation. And finally, we have a comment on the conditions proposed in the staff report. I don't know if you want me to talk about this now or in a few minutes.
Nope, go ahead now, because I actually just took note of them all just to be sure I understood what they were as well. So go ahead.
I'm only going to discuss condition 5, I believe it is, and that has to do with the requirement for a noise study, if I'm not mistaken. So one of the requirements they're requesting is a noise study be prepared. Through discussion with city staff, I understand that trigger is from the airport authority. What we would say is there's sorry, just one second. There is residential development both north and south of the property. It's in a well-established residential neighborhood. And actually in my presentation, I think it's the second last slide, slide 9, it shows Annex 10 from the official plan. I've identified our site. It is within the, I believe it's airport vicinity development zone. If we could go back to the, yeah, thank you. So it should be slide 9. I got to fix all the blurriness in all these slides. But you can see we're at the top. I've circled it in red. It's 799 Melville Crescent. It's identified with an asterisk. We are just within the airport development zone on the outside. I would think instead of doing a study to determine if aircraft noise would affect a future house on the vacant lot, that sufficient warning would be to register a warning clause on title of the newly created vacant lot, warning any future purchasers that the property is located near an airport and may be subject to aircraft noise. I would say this is sufficient mostly because we're not close to the, I think it's 25 line that's dashed in black, as well as we're not close to any of the runways or directly in the line of any runways. So those would be my comments. Thank you.
All right, thank you, Mr. Bolden. I would agree with you with regards to the airport noise in terms of a noise study. The noise study is really to identify construction measures, mitigation measures in construction. That's what that's about. They want to make sure that if you have a noise study, you've got a list of recommendations that somebody who's looking at the building permit or the building, like the plans, can actually ensure that that was done. What we have been doing more often is, in fact, going with a noise warning clause unless we felt it was far more within an area that would be impacted. So, totally understand your your, I guess, want to change it from a noise study to a noise warning clause. A development agreement is still required one way or the other, but we can certainly make that switch. All right, so questions from the committee? Anyone? Mr. White?
Yes, Madam Chair, you recall we had some discussion with respect to that encroachment and the potential to include a condition that addressed that encroachment for the benefit of future purchasers of the parcel. I'm going to suggest that, seeing as we do have an agreement that's required to implement that noise attenuation provision, that we also include in the agreement clause to address and put on notice subsequent purchasers that the existence of that encroachment that may, and I understand from the presentation that there are arrangements being made to have it removed at such time as the adjacent parcel might redevelop. I think that's what I heard. I think that could be incorporated within the clause. I'm going to suggest, I quickly jotted down some thoughts on a wording. If you bear with me, I can present those.
Before you go there, Mr. White, I guess I'm trying to think this through a little bit, because when we ask for a noise warning clause, I'm just trying, so the beneficiary there to a noise warning clause for the airport is to, I had a thought earlier, and it's unfortunately really has slipped my mind, but I guess I'm trying to figure out. So if there's a noise warning clause on title, what we're saying is that the new owner, can't come back to the municipality and say, look, I want you to put pressure on the airport to stop operations because the noise is a problem. That, or the road, if it's a road noise, we want you to close Eunice Road because we feel, or wherever, that the road noise makes too much. So what are we trying? So what would happen then if we put because it's going to be obvious encroachment is there, right? So if you're looking at a reference plan for the sale anywhere, you're going to see it. So what are we saying? We're saying that we don't want the prospective purchaser then to have an ability to come back against what the municipality on this. Like I guess I'm trying to figure out, what does it really do, and does it mean then that we're saying if we approve this severance the way it is with the encroachment, that somehow, like, I don't think we're at risk. The municipality isn't at risk in any way, in the same way that the aircraft noise is an issue. So I'm just like, I see them as kind of very different things, and I'm kind of wondering.
I'm just concerned that we're granting a severance. We're allowing development on this land without putting subsequent purchasers on notice. Somebody coming at the city. Somebody coming at the city suggesting, well, you people knew this situation. Why didn't you deal with it and put a notice on title, a warning of this situation when you allowed the lot to be created?
And that would be like, to me, that's got to be our concern here. It's the only thing that makes sense to me, is that we think somehow there might be a recourse by that prospective purchaser to come back against the municipality for having created a lot like this in the first place. Mr. Chan.
I'm inclined to agree with Mr. White. I see these both as being warning clauses to all subsequent purchasers of that lot. One is to warn them that they may be exposed to aircraft noise, and the other is to warn them that they're, at least at the time of the approval of the application, that there was an encroachment on the property. It may disappear in the next year or two, but I think they are just warning clauses for all subsequent owners, and I see them very much in the same light.
I guess you and I would have to agree to disagree on that one, because the reality is why we want the warning clauses is because for aircraft noises, because you don't want any curfews. You don't want a lot of pressure being put on politicians to impose curfews and somehow restrict airport operations. What are we really trying to achieve with a warning clause for something like an encroachment? What's the actual liability of the municipality, and what are we trying to protect against?
In that respect, you're probably right. And to be honest, I'd rather we didn't even worry about it, but there's some concern among some members of the committee. And I think this is a way of at least addressing that concern. From my perspective, I don't see it as an issue at all. But if there's some concern that by approving this severance, that there's some risk that some purchaser, two purchases down the road, may suddenly be surprised to discover that there's an encroachment, at least we've protected everybody against that eventuality.
All right. Any other questions or comments about the application from anyone? Okay. It's getting late.
We're all tired. It's late.
We just want to go. We just want to have that glass of wine at this point. At least that's my excuse. Okay, so on that, I've got no one to speak to this. But I need to open it up. Oh, Ms. Brining, before I do that. Oh, sorry, Ms. Brining, you're muted.
Madam Chair, through you, I'm just, I have not seen a condition like that ever imposed. So I'm just, we're in uncharted waters to do something like that in a development agreement that the noise, the city gets its jurisdiction to impose that because of the official plan requirement. But in this case, it's not, as you alluded to, I see it as two different things as well. And I'm just not sure going forward with a condition like that, what the legal department would comment on that.
That's a very good point, actually, is where's the authority for it? I know what we're trying to achieve. It's a good objective, but I guess we have to kind of think about where we're going with it. And do we allow the buyer beware principle to just reign here and leave it?
With respect, Madam Chair, that'd be my preference, and I think that was the position that Ms. Willis took earlier this evening. It's there. It's clearly evident on the reference plan, on the survey plan. It will go away someday. I'm not sure that the committee should be losing a lot of sleep over this.
Madam Chair, I assure you I'm not going to lose any sleep over this.
All right, so
I would just add it does in fact sort of sterilize that part of the lot for any future development if it's not addressed. So I'll just make that final comment.
All right, thank you. I agree. I mean, I don't think it's ideal by any stretch of the imagination. So, but okay, let's see if there's anyone out there who wants to speak to this application, either for or against. So I'm going to give anyone who has an interest the opportunity now to come forward. Pretty quiet. Okay, I'm going to consider the public hearing portion closed on this application. And I guess we could go to, I did first off, okay, hands in favor of adding a condition about untitled warning of the encroachment. So I'm going to put my hand up. So, okay, so who's in favor? Okay, so Colin's in favor. Anyone else? Ms. Markovich, you're in favor of putting in a noise clause? Okay, so if we go to my majority rules, we're not doing the clause because I don't think it. I'll be honest, I don't know that we have the authority as Redding rightly pointed out, and I don't know what we're trying to achieve. To be honest, that isn't already covered in some other means. So, so that said, I guess we're not going to attach a condition, additional condition. And we are agreeing that if approved, we are going to modify condition number 5 with regards to the aircraft noise to become a registration of a noise clause on title rather than a study. So we're agreed with that. Yes. Good. All right.
Thank you, Madam
Okay,
Chair.
so I think it's time for a vote, folks. So those all in favor of the application. Okay, so there's 4 members in favor of the application. I am dissenting. I will be honest with you. I do not think creating a lot with an encroachment on it represents in any way orderly development. So even though I know, as you said, that it's just rickety and it's probably going to disappear, I just, in good conscience, don't think it's orderly development in terms of approving a severance on that basis. I think there's other things that needed to happen before we got to this point. And a letter saying, I like, anyway, never mind. It's approved. I'll have to say your application's approved, subject to the conditions that we talked about. And I think that concludes discussion on this item. Well, thanks
Thank
for
you very
sticking
much,
with
Madam
us.
Chair.
It's been a long night. Thanks for hanging in. And I'm sure we'll see you again in this new year at some point. So
You can count on it.
yes, I know. That's good. All right, thanks. I need a motion to adjourn the meeting. Thank you, Ms. Willis, seconded by Mr. Hindle. And we're done. Thank you. Good work, everyone, tonight. Thank you, Mr. Hodgins, Ms. Ramirez. You hang in there. Ms. Young, I saw that you've been with us. You were quiet all night, but I saw your name. But people are just sticking with us. That's great. Actually, this wasn't as bad as I thought. I expected to be a little later than we are tonight. So, again, good work. Great discussion. Loved all the points that everybody raises. I think everybody brings so much value to this committee. So thanks so much. Appreciate your time. Enjoy the rest of your week.